Ivalani, we're ready?
Yes.
Very good, thank you.
Recording in progress.
Let me disconnect.
All right. Aloha mai kako. My name is Don Chang. I am the chairperson of the Commission of Water Resource Management. This is the June 18, 2024 meeting of the Water Commission, and it is, oh my goodness, 9:00 a.m. I'm going to go over some meeting protocols. We are holding this meeting as a hybrid. Some of us are a person in the DLNR boardroom of the Kalani Moku building in Honolulu, but we are also holding this meeting remotely via Zoom, and it can be watched live on YouTube. I see Commissioner Rora Kagawa Viviani on the Zoom. For those here to testify in Zoom, we will let you into the meeting when we hear the item you wish to testify on. Please remember to mute your YouTube when you are in the main Zoom meeting room, or we will get an echo. When you enter, please be sure to keep your camera off and microphone muted until the commission calls on you for public testimony. We ask that members of the public testifying on the agenda items be mindful of everyone and limit your testimony to 3 minutes so that we can get to everyone. Please do not use the chat box for any comments because that presents a sunshine issue. People may also testify via telephone, via the phone numbers posted online. Please let our commission secretary, Ivalani Ka'a, know your name and what agenda item you wish to testify on so that she can call on you for that item. You can email your testimony to ivalani.hr.ka'a@hawaii.gov or dlnr.cworm@hawaii.gov. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. I'm now going to read the standard contested case statement. In some of the matters before the commission, a person may wish to request a contested case hearing. If such a request is being made before the commission's decision, then the commission will consider the request first before considering the merits of the item before it. A person who wants a contested case may also wait until the commission decides the issue, then request a contested case after the decision, but before the close of the commission meeting. Any request must also be made in writing within 10 calendar days. If no request for a contested case is made, the commission will make a decision. The commission will treat the decision as final and proceed accordingly. In addition, the commission may also go into executive session pursuant to HRS 92-5, subparagraph A, subparagraph 4, in order to consult with its attorneys on questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities. I am now going to take roll call of all the commissioners. Please state your name, and if you are participating remotely, please state whether anyone is in the room with you. I'll start off with Commissioner Miyake.
Present.
Okay.
Paul Meyer.
Wayne,
Good morning, Chair. Wayne Katayama.
Don Chang,
Aloha, Neil Hannes.
Kathleen Ho.
and Aurora.
Aloha, Aurora Kagawa Viviani, and I am alone.
Thank you. And I do want to acknowledge and recognize that this is Commissioner Neil Hannes's last meeting, and we've really appreciated your public service.
Thank you. Thank you.
He hasn't quite
You're
taken off the Band-Aid as he is transitioning. He is transitioning his new responsibilities and continued public service will be to serve on the Mauna Kea Stewardship Authority. So mahalo for that. Our acting first deputy, Dean Ueno, could you introduce your staff, please? Madam President.
Good morning, Commissioners. Dean Ueno, Acting Deputy Director for the Commission. With us today in the room is Ivalani Ka'a, Deputy Secretary, Alexa Daika, Legal Fellow, Katie Roth, Planning Program Manager, and Liz Rusev with the Planning Branch. Also online, we have Ryan Imata, head of our groundwater branch. And you want to introduce Brittany?
Aloha, Commissioners.
Aloha.
Katie Rock, head of the planning branch. I wanted to introduce Brittany Key, who's joining us remotely. She is our intern. She comes to us from Yale University. She's going to be with us for the next few months, helping out on a variety of projects. She has previous experience working here in Hawaii. She's from Hawaii. She's worked for the Office of Sustainable Development, OPSD, assisted them with some of their plans, including the Hawaii 2050 plan. Brittany, if you wanted to say a quick hello to everyone.
Sure, just really quick. Thank you for that introduction, Katie, and thank you for letting me listen in on this meeting. Looking forward to my first commission meeting. Thank you.
Thank you so much, Brittany. Did you want to share anything more?
I'll just share, I'm a graduate student right now at the Yale School of the Environment, and I believe, as Katie stated as well, I worked for almost 2 years at OPSD, so I'm looking forward to working with another state agency.
Very good. Thank you so much for sharing your time with us today and over the next couple of months. We look forward to having you attend more of our meetings. Thank you. I also would like to recognize our Deputy Attorney General today is Colin Lau. So with that, we're gonna take the agenda in the order that it's been noticed. So the first agenda item is item A1, the minutes of May 21st, 2024. Commissioners, do we have any comments, edits, or changes? Aurora?
Sorry. I'll send non-substantive edits to Iolani following the meeting.
Very good. Thank you so much. Commissioners, does anybody else have any other comments? If there are none, do I have a motion?
And there's no public testimony.
Oh, very good. Thank you. And Iolani, are there any members either in Zoom for public testimony?
Could you give me one moment to
Okay.
let everyone in?
Okay.
See if,
Okay.
one moment.
All right. Thank you. Anybody in the boardroom here? Oh, we've got quite a few.
Okay, everyone's on
Move
here.
approval.
Okay. Seeing no hands up, a motion has been made to approve the minutes of May 21st, 2024. Do I have a second?
Second.
Discussion. Seeing no discussion, all in favor? Since this is the first vote, Iolani, can you do a roll call?
Commissioner Mieke,
Present.
Present.
Oh, you want me to vote?
Usually I'd say aye.
I have a hard time making a decision. Aye.
Commissioner Meyer,
Aye.
Commissioner Katayama.
Aye.
Chair Chang,
Aye.
Commissioner Hannes,
Aye.
Commissioner Ho,
Aye.
Commissioner Kagawa Viviani.
Levity.
Hi.
Motion passes unanimously. Oh, I can tell this is going to be a good, fun meeting.
Actually, there is an official motion
That's
as
a-
present.
that's a vote.
Yeah, that's a vote.
Okay, Dean, we'll move on to the next item agenda, B1. And I do want to thank the commission secretary for keeping the minutes timely. Thank you very much for that. Is it Dean?
Good morning again, Commissioners. Dean Ueno for the record, Acting Deputy Director. Item B1 is determination approval of draft agenda by the Commission on Water Resource Management in section 92-3.1 HRS for the Commission to conduct a site visit to privately owned lands to view the Punaluu Stream Restoration Project. Kamehameha Schools, Punaluu Stream, on June 27, 2024, as a limited meeting due to the impracticability of public attendance for reasons of danger to health or safety, or in the alternative that on-site inspection is necessary for future management purposes. So last month, Commissioner Hannes, being that this was his last month in June, had forwarded me an article that came out in the Imua magazine, which I believe is the Kamehameha Schools alumni magazine, speaking to the stream restoration project. And we'll forward this out to you folks after the meeting. Interestingly, Punaluu is kind of where I first cut my teeth as when we started up the stream protection and management branch. It's also where I met Commissioner Hannes for the first time, and appreciate all the leadership and guidance that he showed out there in Honolulu. And so it's kind of funny that it's full circle at this point. Unfortunately, we were originally working to schedule a site visit, as you know, on June 17th, but due to scheduling issues and working with the Office of Information Practices, we decided to push it back to June 27th while Commissioner Hannes is still on the commission. And so the submittal before you is to conduct a limited site visit. As you saw in Exhibit 1 is the draft agenda. So we also will have some commission staff out there. But because it is private property, Kamehameha Schools lands, it'll pretty much just be you folks and commission staff. So if we have any questions, available for questions.
Commissioner Neo, did you want to add anything more?
Well, I thank you for the accommodation and the long memory. This goes way back. But please don't just do this for me. I mean, I think this is a really amazing project, and it's a Kamehameha stepped up in a big way. We've created the plans, but the heavy lifting was done after I retired. And to the credit of the team there and their trustees who made that investment to restore a system to what it should be, and the abuses of the past in terms of really optimizing certain other values other than the value of the ecosystem there and the stream function itself came at a high cost. And that created great risk to the environment as well as to financial interests there, the homes, and they constantly got flooded and so forth. So it's we've done that elsewhere, that's happened elsewhere. And so we thought this would be a model or an example to, well, what can you do? Can you go back and can you restore? And so I just thought it would be a worthy example for the commission to review. Thank you.
Thank you. Commissioners, any questions or comments on this agenda item? All right. Do I have a motion? Oh,
I have a
yes.
brief comment.
Yeah.
Just it's trivial, but I'll just say I remember before the restoration project, I was working part-time with SWCA, John Ford, and Bob Kinsey, who's recently passed. And I remember walking the stream that was like a highway and discussing the flooding issues. So I've been out there and I think it's a really neat opportunity to be on site. So I will not be joining.
Cool. Thank you for that comment, Aurora. Commissioners, any other comments, questions? Do I have a motion? So public testimony. I keep on forgetting about members of the public. Anybody in the boardroom here to provide comments on item B1? Okay. Anybody on Zoom? All right, thank you. I'm going to close public comments. Yeah.
Can I add that because the title is determination of approval for this limited meeting, may we ask that the approval include approval of the proposed agenda?
Okay. Board members, do I have a motion to support? what
Move to
Colin just
amend the additional approval of the agenda as submitted.
said? Very good. Okay, do I have a second?
Second.
All in favor of the motion and the amendment, please say aye.
Aye.
Aurora? Oh, okay. Motion passes unanimously. Thank you so very much.
Thank you, Commissioner.
And thank you, Neil, for coordinating and part of this event. Item B2.
Hey, good morning, Chair, Commissioners, Ryan Imata, Groundwater Regulation Branch Chief. So item B2 is the modification of the existing delegation to the chair that was approved at the December 19, 2023 meeting. And this is regarding delegation for well pump permits when the well is in compliance with the standards and for pumps less than 27 gallons per minute. And the final part is the delegation to the Deputy Director for other groundwater permit related approvals, not necessarily permit approvals. So I'm assuming you all read the submittal. I'm gonna kind of gloss through some of the maybe historical stuff and then maybe focus more time on the things I think you guys are gonna have questions on. So again, that was I had stated the summary of the request in the title. For background purposes, prior to 1997, all well and pump permits were presented to Commission for approval, except in certain instances. In 1997, that was kind of the pivotal moment for regulation where the Commission adopted the well construction and pump installation standards. And in doing so, delegated authority to the chair to approve permits. From that point, 1997 to 2023, all commission chairpersons allowed deputy directors to sign well and pump permits and various associated documents. But there were instances when well and pump permits were presented to the commission for approval, particularly in management areas and the other areas that I've shown in the submittal. Then again, in December of 2023, Commission staff presented a submittal to enter an agreement with DLNR's state parks to drill a deep monitor well on the Hapuna Beach State Recreation Area. During the discussion, Dr. Scheuer expressed concern that the well's delegated authority to the chair wouldn't provide the ability for the public to provide input on the commission's consideration. Later in that same meeting, I presented a submittal that modified the delegation to the authority for chairperson for approval. And there was more discussion about that, particularly where there was cross connection of aquifer bodies. And so we're going to address that later in the submittal. Dr. Scheuer also wanted to make sure that there was transparency in our permit reviews and that the public had an opportunity to comment on applications. The approved recommendations were as described below with the amendments underlined, so I'm not going to go into the details of those. During that, or in response to that submittal, there were a couple of concerns from Department of Water Supply for both Hawaii County and Honolulu, and so I described those below. I'm going to skip ahead to, let's see. So I'll skip ahead to how we are looking at some of the issues that the county brought up. In terms of discrete aquifer bodies, it is true, I've found in my experience that there are inconsistencies in the way that the commission regulates high-level aquifers versus basal lands. For example, Lanai is looked at as two central high-level aquifers and then outlying aquifer systems that have basically zero sustainable yield. Another example is the Waihewa aquifer system on Oahu that has high-level water that spills over to the north sector and also the Pearl Harbor sector. So staff feels that it's appropriate to incorporate studies into the next update of the Water Resource Protection Plan to really start to think about discrete aquifer bodies and explore setting some sustainable yields by hydrogeologic boundaries. And that also includes Keauhou on the Big Island, where we might start looking at high-level versus basal lenses and even that deep confined lens. We are ready for a standards update. And again, that might address the issue of cross-connection of aquifers. And another update that we need to do for the standards is updating the policy on the depth of drilling for confined aquifers. One issue that was brought up was water being used for its highest and best use. And we can do that via water use permits in groundwater management areas. In non-groundwater management areas, as Dr. Miyake brought up, there's no current mechanism to regulate end uses. We are exploring options to address this issue. And I'm going to be presenting a submittal to you probably in the next couple of months that hopefully addresses some of those concerns. in terms of the bifurcation of permits, so basically separating out the well and the pump permits, there were thoughts about that submitted by the counties, and we agree that drilling a well prior to applying for a pump installation permit gives us and the applicant better data to evaluate potential impacts. But some applicants may want to have both well and pump permits on hand prior to investing money into a well, where they think that if they can't get a pump installation permit, they shouldn't invest the money in the well construction part of it. So we agree that there needs to be better guidance for the Kapakai analysis for people that submit applications, and also need to find or maybe define reasonable mitigation strategies when traditional customary practices may be impacted. And I think that we can do that in the Water Resource Protection Plan. So the proposal that we have for revisions to the delegation is delegating authority to the chair to approve all well construction permits if they're in compliance with the well standards, except for a couple of situations. So where the well is artesian and flow can get to the surface and leak, there's the potential for impacts to the environment if a well is leaking at the surface, if it's under artesian pressure. Or, as Dr. Scheuer identified in the Hapuna case, if two aquifer bodies are penetrated and there's a potential for short-circuiting one aquifer with another. So basically what I'm saying is that those types of well permit applications should come to the commission for approval, but everything else gets delegated to the chair for approval. Number 2 is all pump installation permits greater than or equal to 27 gallons per minute will need to be approved by the commission, regardless of whether they're in or out of a groundwater management area. And this is going to be, I think, the most controversial part of my submittal is people are going to ask me why we identified 27 gallons per minute. And so I put some of the data into the exhibits, but I do have more data available to share with you so you can see how we arrived at 27. I don't think it's a necessarily arbitrary number. And so I can kind of go into the details about why. I think there are going to be some advocates that say they want that to be higher, maybe, and maybe some that are advocating for that to be lower. But basically what I did was I had our geologist on staff. He did a pretty thorough analysis of installed pumps and looked at how much they were pumping on a daily basis. And so generally what we're finding is that pumps that are installed at about 27 gallons per minute were pumping anywhere from 0 to 1,000 gallons per day. But that's not to say that all of the pumps were pumping 1,000 gallons per day. It's hard to equate gallons per minute with gallons per day because you can pump a well for 2 hours, or you can pump a well for 24 hours, and you're going to get a different quantity in terms of a daily amount. But what I was trying to do was trying to correlate the instantaneous rate gallons per minute to the amount of gallons per day. And what we found as a threshold for a cutoff was it can be up to 1,000 gallons per day, but on average, maybe it was closer to maybe 500 or 600 gallons per day. We compared that with the water system standards from the county water supply departments and found that average daily domestic needs are about 400 to 600 gallons per day per unit. So setting the threshold at about 26 would more or less filter out any individual domestic wells from needing to come to the commission for approval. So there is the issue of individual domestic having gigantic landscape areas. And it can be argued that in non-management areas, looking at highest and best use of water should really be evaluated by the commission and should maybe even require in non-management areas. Potentially, the commission can say, maybe you got to look at an alternative source of water for your landscape irrigation needs. I also said that there are some instances where pumps less than 27 GPM should be presented to the commission for approval, and this is for full transparency. So where the pump intake setting is roughly equivalent to an adjacent stream elevation, that's where we have concerns that pumping a well could impact surface water flow and might require an amendment to the in-stream flow standards. Or where an aquifer has reached sustainable yield in actual withdrawal, or where there are disputes or concerns that need to be addressed in a public setting, or any other instance where staff feels that additional discretion is warranted. And remember, this is not the approval of a well in and of itself. It's just making sure that if the chair has any concerns that that the chair feels like not comfortable with approving the permit, we can, convert the how do we say it? Have anything reviewed by the commission. Generally, all pump installation permits will need to go to the commission for approval if a water use permit is necessary, regardless of the pump capacity. So I also talked a little bit about delegations to the deputy, and those are kind of routine things where acceptance of applications for review by government agencies, granting extensions, and the follow-up documentation, the well completion report acknowledgements, and the certificates of completion. I had some follow-up actions for us, which is propose aquifer revisions to account for hydrogeology, and we can update the commission within 6 months. We can start Hawaii well construction and pump installation standards and update the commission within 6 months. We can propose Kapaakai guidance document and update the commission, and I put that on a shorter time frame because we are working with a model from our engineering division about Kapaakai guidance. And so we're currently working on that. We can update you within 3 months. And that's a huge question from a lot of drillers and in fact, the departments of water supply about what exactly do they need to do Kapaakai analysis. And then we can incorporate guidance for reasonable mitigation strategies into the Water Resource Protection Plan and update the commission again about that. So again, my recommendation, or staff's recommendation, is that all well construction permits where the well is in compliance with the standards are delegated approval, except where wells penetrate 2 discrete water bodies or where artesian sources bring water to the surface. Number 2, pump installation permits for less than 27 gallons per minute in throughout the state, whether designated or non-designated. Except for the following conditions: pump intake setting adjacent to stream elevation, as I said, where aquifer has reached sustainable yield, where there are disputes or concerns that need to be addressed in a public setting, or any other instance where staff or generally the chair feels that additional discretion is warranted. And then pumps less than 27 gallons per minute where a water use permit is necessary should go to the commission. Staff's also recommending commission delegate authority to the deputy director for approval of the more routine things, acceptance of applications for review, extensions, and completion report acknowledgements and certificates of well construction and pump installation completion. That concludes my presentation of the submittal, but I wanted to also add, I reviewed all of the testimony that came in regarding today's submittal. I would say I'm not going to go over the ones that were in support of the submittal, but I did have a email conversation with Dr. Scheuer this weekend. I don't think he's able to attend today to provide comments, but he wanted me to let you know that some of his comments were, he still has concerns about delegation of the wells from the commission to the chair and the lack of being able to comment, which I've had a conversation with him about. We're trying to implement a project whereby all applications are done via an online form, and we can post all of our applications on our website as soon as they come in, or maybe as soon as they're accepted, so that the public can comment on them. And I think that'll help with the transparency issue. And Dr. Scheuer did state that item 1A of the recommendation is difficult to implement at the staff level. So he has concerns about where there's the potential for cross connection of aquifers. He's saying it's difficult to implement. I'm not, 100% sure what he means by that, but I'm going to talk about that with him when he becomes available to talk about. And yeah, otherwise the comments that came in generally from drillers and Department of Water Supply and other agencies were in support of what we're proposing. So with that, I will stop talking and entertain any questions that you have.
Thank you very much, Ryan. Commissioners, do you have any questions for Ryan?
Yeah.
Larry?
Just to summarize then, basically any household domestic wells are below the line. That's why you picked the 27, right?
Yeah.
And second, even if the delegation is given, in individual cases, that still come to the commission. When, for example, what you're talking about, cross between aquifers and surface water, et cetera. So that it's not an absolute delegation. It's sort of a routine delegation with exceptions, which when things arise on a particular application.
Yeah, I was trying to I was trying to identify any permits in the 27 years that I've been here, looking at where I think that there are going to be concerns. I would love to focus more of our effort on where I think that there are potentials for impacts to other resources or other users or traditional customary practices or whatever. And I think this is a good balance between filtering out things like individual domestic uses where the use is so small relative to sustainable yield, but bringing to you the issues that are much bigger. So yeah.
Yeah, all right.
Thank you. Aurora?
Thanks, Ryan, for this. In trying to read the esoteric document that is the Hawaii Well Construction and Pump Installation Standards, I noticed it was revised in 2004, but that's not referenced. And so you told us about the establishment in 1997. Is there anything to note about that 2004 revision? And I'm just going to say I noticed like approval by the chair was noted about 40, or chairperson was noted about 40 times. So there was a lot of like delegation already in that document. Can you kind of explain how?
Yeah, the delegations in this. So I can't speak to the specifics of the differences between the 1997 and 2004 standards, but I know at the time, at the time that we first implemented the standards, we were having a lot of comments from drillers and developers and I think just the general public about things that needed clarification. So I don't think the 2004 standards necessarily revised anything from a policy procedural standpoint. I think it was more details about construction, construction details that were amended. So the delegations, them in and of themselves were kind of a clarification of the more routine things that we do, and not specifically, permit delegations. I hope that answers your question.
Not quite how I read it, but I'm not a lawyer. The second question I had was around recommendation 1. And Otta Well was just on our radar. So I was going back and recalling that there were 8 alternative actions for keelhole non-designation. And the first of those was that permits, the commission will refer all well permit applications to the Moku. There's a clearly delineated process. And so how would this proposed recommendation, I mean, it doesn't seem to address that there's specific close to designation areas that may be important for us to consider, or for there to be a public process on. I mean, one, because it's already established that for keelhole, there is a need to address the well construction, or what's this all permits. And so how are we folding that in, or can I mean, I was going to suggest an amendment there, but how are you considering those sort of regional specifics
Yeah, no, that's a good question. So here is the thing about Keoho, and I don't know, I can't tell you the answer to this, but I think there have been some statements that specific to Ottawell, that there was nothing in the 8 requirements that required us to bring it to the commission. But in my recommendation, I think where the chair doesn't feel or feels that there are things that the chair wants to make sure that there's public disclosure on and public input, the opportunity for public input on, we can take it to the commission, right? So so basically what I'm proposing is not saying that everything blanket, gets delegated to the chair. There are opportunities, and I think Keoho is one of them, where the chair can take the approval of the well permit and or the pump permit to the commission. So again, it's just very specific to the area, but I will say that like I said, I think most of the concerns related to the quantity of water and the potential for threats are first covered by the fact that most of those areas are designated water management areas. So, all of those are going to come to the commission anyway, right?
Sorry, what I was referring to are places that are maybe near to designation or not designated. So just for the record, I'll refer to it was February 14, 2017, 8 criteria were proposed as following actions as alternatives to designation. The commission will refer all well permit applications to the Almoco system for review and recommendations to protect traditional and customary practices that are exercised and may be affected by the proposed application. If traditional and customary practices are found in the proposed permit area that may be affected by the proposed action, special conditions will be suggested to mitigate the impact of the proposal. If the well operator and landowner do not agree, then the staff will present applications to the commission for decision making pursuant to HRS 174C84F and HER 13-168-12H. And so I guess I just want to understand, if we decide this, are we, does that supersede? How do these two sort of decisions?
I see. I don't think that's
codify
superseded.
that there are certain just put some address that there are certain areas that we will need to have more discretion on, and then and not leave it up to the chair who comes and goes and may or may not know about certain hotspots.
I do see what you're saying in terms of does this delegation supersede that? And so we can maybe add in some language in there to say that this doesn't supersede areas where there are the commission imposed requirements for things to come to the commission. Yeah, I agree.
Cassie, do you have
So I have a question about the delegation. I understand that there is, that we are, the proposal is to delegate to the chair. I understand that. My question is this ministerial or is this versus rulemaking? So it's a legal question. And then the other question I have along the lines of what Aurora was mentioning, which is there a certain criteria that you will be, that is part of the recommendation for the chair to make that determination as to what comes to the commission? Like for the Department of Health, we have a statute that says if it is in the public interest to bring something to require a public hearing, the director may require a public hearing on a permit issue. And then it sets forth, in the statute itself, it sets forth some criteria. So I'm wondering how, it's a legal issue, I think, but I'm wondering how we would address that.
Good question. I mean,
Regarding,
Go
go
ahead,
ahead,
Ryan.
sorry, I'm sorry.
No,
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 go
go
ahead.
ahead. I'm not the attorney here,
Yeah,
so.
no, and
please.
in this case, I'm,
And I'm not either. I mean, in this case, I am not either. So,
and I'm not rendering a legal opinion either, although I'm, but I mean, quite frankly, that's why I brought this to the commission in December 2023, because I just felt that that was, in light of the comments that we were receiving, and this came up in Hapuna about traditional customary practices, 343, that there seemed to be a question as to, shouldn't this be a matter that's really brought before the Water Commission, not just delegated to the chairperson? I mean, I think staff has tried to attempt to craft exceptions. So I don't know if I would necessarily say it's ministerial, because there are discretionary provisions that may be triggered. And I think Aurora's comment is a really good one, that there should be under maybe a 1C that says otherwise, shall not, something recognizing that where there are commission decisions or determinations, that does not waive the commission's right to oversee this. So something to that effect. But because I too, I felt really uncomfortable with this sort of this unlimited delegation. And that was probably more because I wasn't as familiar, but I also thought that, that there are some things that should be brought out to the larger public. I think Ryan is talking also about the Kapa'akai analysis, having greater guidance. So that can provide a staff, the opportunity. Also the public website, creating an opportunity where everybody can see all applications. Now, whether that is, that at least provides another opportunity for the public to know what permits may be the commission may be looking at, or the staff may be looking at. But balancing that against, looking at all of the testimony that came primarily from the water departments, recognizing we've got to find a balance between how do we facilitate some of these smaller requests versus how do we differentiate those that are more, that do require greater review in a public forum by the Water Commission. Wayne, did you want to also share
I
something?
was just going to ask, historically, how have we handled all of these delegations? Has it been rulemaking or has it been
No,
ministerial?
it's been through board action. The board has authorized.
So we're consistent with this
Yeah,
action today
yes,
then?
yes. So I don't think, I'm assuming that previously there was a attorney general, they were consulting with the attorney general's office, and the delegation was not rulemaking. I mean, I will say for the land board as well, there's a lot of, just delegating to the chairperson to negotiate a contract or, 343. So I don't think that this was necessarily, I don't believe this is rulemaking.
so I think the delegation itself is one action, and I don't think that is rulemaking, right? So I think we have the authority to delegate to you, and that's not rulemaking. It's maybe some other aspects of it, which is what criteria, I don't, and there's a body of cases, which is why I thought we should, it is a legal call, but there are a body of cases where internally, the police department or an agency can set forth different criteria, and that is not considered rulemaking. So I just didn't know where we sit. Not the delegation I'm clear about, but where we sit on some other aspects of this this request, like 27 gallons per minute, like when the chair decides when the chair is able to decide what should go to the greater commission, those kinds of things. But there is that, there are cases that address this, which I'm just not familiar with. So.
No. Are you suggesting that we seek Deputy Attorney General counsel on this before we take an action? Or Colin?
It's up to you.
Let me ask you a question another way. Are you okay with the recommendations that are explicitly stated here? That there are delegation subject to certain exceptions?
So I'm okay with the delegation itself. I think we can delegate to the chair.
Right.
I'm okay with that. It's the exceptions that I'm sort of,
Yeah,
I'm on the fence on whether we have the authority on the exceptions or do we have to do something more? And it's just that I am not, in my former life, I remember that body of cases. I'm just not as familiar with that line of cases at this point. And what I don't want us to do is to act on something and then get.
So it's not the fact that we're making these exceptions, it's the fact how we do it,
Correct.
how we implement them.
And whether we actually have the, whether we have the authority versus rulemaking. So it's just, I'm just interested to see what, if the staff has researched this, if our Attorney General has some thought on this.
no, I think that's a valid the question regarding whether the chairperson in its discretion to say, oh, no, I don't think this is of public interest. I'm not going to, so I understand. Larry?
Yeah, I really don't like what's happening here, which is we're starting to get into such details of a delegation that it's going to be meaningless. The other thing is that I don't know of any bar that says we have to, if we're going to delegate, we have to delegate absolutely. We're only talking about delegating part of a decision-making or a way of looking at things. So I think it's irrelevant that we have to carve out exceptions and then we have to maybe look at rulemaking when we talk about delegation. When we're going to delegate, we're going to delegate. And I don't see any problems with delegating authority. Again, as I say, I'm concerned if we get into too much detail about what we're delegating. I'm fine with the language here. And from the presentation that was given, the explanation is satisfactory to me.
Other commissioners, any questions before we take public testimony? Let me ask you, Ryan, did you consult with the Attorney General's office on this matter?
No, but I think Colin, I think you guys did review the submittal. And I was trying to make sure that anything that was delegated wasn't, how do I say this? The delegation is for approval, right? So there's some discretion in what's delegated, but was trying to take out the discretion so that I was being very specific about which things get delegated. So again, I can't comment on the legality of that. But I think if the commission approved the specificity with which things have to go back to the commission, I wasn't aware that that was a legal issue.
Okay, let's take public comments and then we can go back to this session. I do have who signed up, Roy Hardy. Oh.
Okay.
Roy, are you on the line? Okay, go ahead, Roy.
I'm here. Thank you,
Morning.
Chair. Aloha, Commissioners. For the record, my name is Roy Hardy, formerly Groundwater Protection Manager for the Water Commission. I didn't really want to get into too much detail. I know I only got 3 minutes, but I was very happy to hear the discussion that the Commission was going through, primarily about the issue of is this rulemaking or not. And just a little bit of background, and some of the statements that were made and questions that were asked. Kagawa Viviani brought up, I didn't even know, 40 times that delegation was mentioned in the 2004 OA construction standards. And the 1997 and 2004 updates there was a lot of public information meetings, meetings with the public, meetings with all the drillers. There were presentations at conferences all about these things, and there's a lot of input. And these took years to arrive at these details. There are a lot of them. It's very complex. Some of the examples I was reading through in the submittal about this cross connection issue, it sounds like it's something new. It isn't. It's addressed already in the construction standards. You know, saltwater wells need to be solid casing all the way down to saltwater and grouted all the way through the freshwater to protect the basal aquifer. Similarly, if there's cross connections with perched aquifers while you're going down to find basal aquifers, that needs to be closed off, and those are in the sections of casing and grouting as well. So I was a little bit scratching my head on that, but all these details aside, it seems like and I was happy to hear this rulemaking, because this is going to affect everyone, especially when you're delegating with these exceptions. And the first exception, I can tell you, 1A, wells that penetrate 2 discrete water bodies. That happens a lot everywhere, almost. Almost all the wells on Kauai, that happens. It's an old island, so there's a lot of layers of low permeability where you run through, and there are a lot of perched aquifers, confined aquifers. In East Maui, there's lots of perched aquifers. On the Big Island, Keauhou, there's lots as well. So overall, it just seems like if you're going to make these kind of distinctions and exceptions, it really sounds more like kind of an update to the construction standards themselves, if that's what's being sought here, if there's special cases. So kind of a rulemaking thing. So I would agree with what was discussed, that maybe the AG should weigh in. Sorry, Colin, about about whether this approach really is rulemaking. Commissioner Kagawa-Viviani brought up, Keauhou and all these conditions. Well, that's a special case because of the non-designation. So that's not really rulemaking. And I think the first condition she read out was this, collaborating and talking with Ahamoku and bringing construction permits and pump installation permits in the non-designated area if conditions that were discussed were not agreeable to the applicant. You actually had an example of that, and that's why that special condition was put into the non-designation proceedings and accepted by the commission of the Kohana Iki project, which is right next door to the national park. And just through the regular process, the delegated process, and discussing the applications, what came to be agreed upon by all the parties was, hey, put in these monitor wells, 3 monitor wells, and they were put in, and they're there, and I think they provided very good information, which actually helped with the designation proceedings as well. So that was just kind of codifying that special situation in Keauhou, and especially with the interest in designation. So I don't think that's a rule. It's just, here's this special place that there's a lot of concern. And there was, able to arrive at, I guess, reasonable accommodations and conditions with the applicants and the people of that place. So again, I think my time is used up here, but I do like the question is this overall approach rulemaking or not? That's kind of my question. So thank you.
Thank you very much, Roy. Appreciate the comments. I have next Andrew Choi.
Hello, Commissioners. Andrew Choi with the Department of Oil and Lands. Department appreciates the opportunity to provide testimony in these items, or this particular agenda item. Thank you. First off, the department was not consulted on this matter. We appreciate the importance, the role that the Department of Water Supplies have in water development and delivery in Hawaii, and are glad that they were considered. The department is both a water purveyor and public trust use of water. We, however, were not consulted. We were aware of the agenda item when the agenda was posted and had access to the submittal on Monday, which was also our commission meeting. As Ryan acknowledged in his presentation, he did reach out to Dr. Scheuer over the weekend, but it wasn't really sufficient time for us to really digest this submittal and process its implications on the department's ability to provide water to its beneficiaries. Seaward staff, conversely, worked hand in hand with us well over a month on another agenda item on your agenda today. So it can be done to reach out to the department in advance, well in advance of this presentation. Also, secondly, on transparency for DHL and other public trust users and the general public is still an issue. We appreciate that the submittal raises the importance of public information and transparency. However, the recommended action, especially to the extent that expanded areas of delegation to the chair depend on notice in the Water Resource Bulletin. I think Ryan also acknowledged maybe posting these applications online. That is a good solution, but I think other solutions for transparency can also be explored as well. Delegation removes due process. For the expanded areas for delegation, well construction permits, certain pump installation permits, this will remove due process for the department and its beneficiaries in all instances, except when we are the applicant. Cumulative impacts are not addressed. While exempting some small domestic wells can make sense, even in those cases, the cumulative impacts of multiple wells should somehow be addressed. This could be significant adverse impact to the department and other public trust uses of water. Efficiency is a worthy goal, but the submittal lacks some quantification of the problem and proposed solution. For instance, it could talk about how many of these permits come before staff each year over maybe the last 5 years. And if this action were to be approved by the commission, what the expectation on the time to process the permits, what is the difference in time? How much time do we hope to save by this? I don't think that was clearly communicated. So I don't know the extent of the issue based on what was presented and whether or not this is an adequate solution to address the issue. So the department does suggest deferral of this matter until these issues would allow for further review and analysis by the commission and its staff. However, we understand that there are other differences of perspective and discussion among the commission as well as other public testimony. So in the absence of a deferral, the department, some of the department's concerns could be addressed by modifying proposed action to add an F to the A through E list of pump installation permits that are not delegated as follows. So by adding an item F, pumps in aquifers where the Department of Hawaiian Homelands has a water reservation, we would like to see added as one of the exceptions should a deferral not happen today. Thank you again for the time to testify. And if you have any questions, I'll be happy to answer.
Thank you, Andrew. And I appreciate your recommendation. You indicated that there may be other methods of notice. Did you have another suggestion?
I think posting it online, posting it in the water bulletin, those are good first steps. I think other methods could be the environmental notice. I think that receives a lot of a greater deal of circulation and viewability, posting it in the newspaper, public notice. taking out an ad in the Kauai OHA newsletter that OHA produces in other form. So I do think there are other ways to get the word out and be more transparent, but those are just some recommendations off the top of my head.
Thank you very much for that.
Thank you. You make a good point that presumably we're doing this to make the process more efficient, but that really hasn't been explained and addressed in the report. And for Ryan, perhaps to respond, if something has to come to the commission, what's the typical time frame for approval versus if we delegated this, how efficient would the system be? Can you help us understand the gain, the benefit as to what we gain from delegation?
Well, I can tell you that our statutory deadline for approval of permits is 90 days, regardless of whether it comes to the commission or whether it's delegated approval to the chair. The problem with bringing all applications to the commission is we have to take the time to draft the submittal and prepare all of the documentation that for wells that comply with the well standards. And I think that would increase our processing time, and it has increased our processing time quite significantly. I'm going to add too, and I don't know that this is necessarily pertaining to the delegation in and of itself, but groundwater regulation branch is severely understaffed at this point for the amount of things that we are tasked with right now, which includes the newly designated Lahaina and potentially Waianae designation, in addition to now having to bring all well permits to the commission. It not only adds a time component to our ability to process, it takes away our ability to really focus our efforts on areas where I think that there are significant concerns and significant potential impacts to resources, including tradition and customary practices. And I'll identify two of them. One of them is in the north sector of Oahu, where there are really a lot of concerns about these large residential units on agricultural land coming up. I think that's something that we need to focus our efforts on to bring to you guys to look at in a more, so that decisions can be made in a more open and meaningful way. The other one is out in Kukio on the Big Island, where we have a brackish lens that we do have concerns about the lens potentially becoming saltier. And those are areas that I want to focus our efforts on to make sure that we're providing the adequate protection. Every time I bring a Hawaiian Paradise Park well to you for approval, that is like 0.005% of sustainable yield, takes away the ability for groundwater regulation branch to focus on things that are more important. So there's not only the time commitment, there's also the ability for us to focus our efforts where I think that there are concerns.
Point taken. Thank you, Ryan.
Larry?
Yeah, if I remember correctly, this issue came up because Chair was concerned about an open-ended delegation, and this is an attempt to restrict the delegation. What's happened in the past? I don't know of anything that's happened in the past that the old system of delegation was leading to some problems. All I hear now is people are concerned about, because it's been brought out in the open, that we want to sort of restrict the delegation. So it seems backwards that here we are trying to restrict the delegation, and people are concerned about how we're restricting the delegation, where in the past it's been an open-ended delegation.
I have another question. Along those lines, Ryan, you mentioned that we have 90, or that you have 90 days to issue a permit. Is the consequence, if you don't issue the permit within 90 days, it will be deemed approved? Or what is it? It's not, I know there's a statute that.
So I've been reading a lot of your guys' rules, the Department of Health rules lately, and I noticed that there is an automatic approval if something isn't reviewed and approved within a statutory deadline. We don't have any of that in the HRS or the HAR. So the read from our AG's office, and again, I don't know if, you know, the answer from our deputy AGs has been that automatic approval isn't done because of lack of adherence to that 90-day statutory deadline.
So what's the consequence, Ryan, if you don't approve it in 90 days?
There is no consequence.
Okay. Okay. Now I just wondered why, I wondered why you said you had to approve it within 90 days. I thought there was a consequence. But
well, I mean, we try, you know, as much as possible, we try to follow the law, right? I mean, that's our job, is to make sure that we follow the law. Unfortunately, again, with the change in delegation and a lot of the changes that are happening, I don't think it's stated enough to the commission that groundwater branch has extreme challenges with getting things done. And I'm looking at who is here to testify. I see Barry's here. I know that there's been a lot of pushback. There have been a lot of people that call me that you guys aren't aware about, that are pretty upset about the process taking so long and how this delegation adds to that concern for time. So on the one hand, I do understand the ability to provide or an opportunity for public input. I respect the fact that there are changes that have happened since 1997, but I'm looking at it from the perspective of trying to make sure that I focus the things that you guys need to see and the important issues, and taking away the things that I think are much more routine and ministerial in terms of people complying with those and not needing to go to you guys for approval. That's all my concern is.
So Ryan, I believe at one time you did some statistics. What is the total number of well permits that come, or well construction and pump installation permits? And because I think hearing Andrew's comments about, so what's the issue? You have, and you're saying that there's so many permits and that you're not able to dedicate the time to the harder issues. So out of the total permits, how many permits would fall under this, number one, where it meets the standards? Because you had given to me some statistics about Hawaiian Paradise, that you said something like over 50% of all the well permits come from Hawaii Paradise. Am I making that up, or is that true?
No, that's very true. And in fact, Ivalani or Dean, can you allow me to share screen? Because I can't share screen right now. Still can't. Okay, here we go. So while the discussion was going on, I just did a super quick report from our database about wells applications that we've gotten since I think since 2019. So from 2019 to today, we had like I don't have a summary number, but it looks like we got about 700 applications, which amounts to about 100 per year. If you look at the aquifer codes, a lot of these are for domestic wells in Hawaiian Paradise Park. So you look at the aquifer code 80801, or I think 80801 is Pahoa in Hawaiian Paradise Park. Most of them, like if you look at all of the pages, I think I have like 18 pages. I think over half of them are in Hawaiian Paradise Park. So you're right. And here, you didn't make that up. 50% is about right. Some of them are in Maui. This is Aquifer Code 6. These are on Oahu 3. And again, these Oahu applications, some of them are individual domestic, but some of them require water use permits. These are Navy monitor wells, which they're constantly pushing us on. And we try to address those because we know that those are necessary to really address the needs of analyzing data around the Red Hill spill. And then there's a lot of border water supply wells, and Barry's here. Usagawa is here from the board to kind of talk about the time, the time frame that we've been faced with having to, trying to get these approved for them too. So again, looking at these are sorted by aquifer codes. You look at if freeing up our ability by delegating all of the Hawaiian Paradise Park wells will really significantly impact our time. Again, we have other challenges. We have staffing issues. We have designation issues. We have a lot of other issues. So I'm not saying that this is a blanket fix-all that's going to allow us to get permits out way, way faster, but it's another step. I think it's another layer that impacts our ability to get work out. So I hope that answered your question.
Okay. Board members, any other questions? I do have others. Is there anybody else in the boardroom that would like to comment on item B2 before I take members on the Zoom? Okay. I do see several. I see Barry and I see Kavika. Did both of you want to provide public comments? Barry Usagawa. Hi, Barry.
Good morning, Chair and Commissioners. I guess I'll go first. We submitted testimony in support of the staff recommendations, primarily because of the streamlining, just the well construction permitting and administrative tasks that are related as practical for administrative expedience. So we make 4 points. One is that the staff is very knowledgeable and experienced and capable, and under the direction of the director and the deputy, working as a team, they determine all the conditions. Certainly the delays have been affecting our projects. It's been at least a year on a couple of them. Even delegated, I might point out that the staff still have to send the permit applications around to for agency review and comment, and that does take a while, in particularly the Historic Preservation Division. But and while those delays are affecting us, and it does affect our ability or the availability of water for affordable housing, and it just exacerbates our water shortage potential from contamination, climate change, induced drought, and wildfires. The third point is that we are aware and bear the risk of the drilling an exploratory well, whether we can find a competent source of water. So we're aware of those risks, and also that conditions will be placed on these permits. Primarily, in Oahu, you have like 3 bites of the apple, actually, because it's designated except for Waianae, and we're working on a petition to designate Waianae. But delegating the well construction permit allows us to find a competent source, do the well testing, developing the information that could be then used to determine the pump installation permit, the sizing, and of course the water use permit. And those 2 other permits go before the commission. So in terms of transparency and public notice, there's 2 other layers or 2 other types of processes that will do that. In particular, for us to drill an exploratory well, Chapter 343, Section 5, when you use state or county funds or lands, we are required to environmental assessment prior to the well construction, and that will disclose the environmental impacts, as well as including archaeological, cultural, and Kapa'akai analysis. And I appreciate the fact that guidelines will be worked on for Kapa'akai, because they're really needed. I think they're a bit loose. And then you mentioned the bulletin. So there are probably other ways to notify the public and allow comment, but that's our testimony, and thank you for the opportunity to provide supportive testimony, and I'm available for any questions.
Thank you, Barry. Board members, commissioners, any questions? Okay, Kavika, did you want to provide testimony?
Good morning, Commissioners, Chair Chang. Kavika Uehara, Deputy Department of Water Supply, County of Hawaii. So yes, we did submit testimony, and submitted testimony in support of the staff's original submittal. But hearing some of the comments and discussion made today, which is very informative, I just wanted to add a couple, I guess, new comments for consideration. I guess first, if there is a revised submittal from staff, then what we hope to be able to comment officially on that via the testimony process. In regards to the item 1A, I believe we recognize and acknowledge if it is a rulemaking decision or discussion that needs to occur between CWRMS and the AG, we respect that. We'll let that go through that process. In regards to Keauhou, we do also recognize and acknowledge the 2017 non-designation decision. So we fully are in agreement with following those conditions or recommendations that came out of that decision, and we'll abide by that. Just to put in, to add to the Keauhou conversation, and we do have at least one, I think, well, construction permit or application in process right now with CWRM staff, and it's kind of been in the process for a couple of years from what I remember. But basically, it's helping us to develop another source to reduce or to actually allow us to get off of using the basal lens sources, such as Kahalu Shaft and some of the other basal wells that we have in the aquifer. So again, we know there's a process. We just want to make sure that everyone understands. On our side, we're trying to develop some sources just to replace some of the older basal sources, so we can reduce our reliance on basal. In addition, some of you folks may know that we're trying to downsize some of our wells just so we have better operations. We can operate a little bit better with reliability. So by that, we lose capacity in some of our wells. So one of the applications, well, construction applications we have in now is to kind of help us restore some of that capacity that we've lost. So. But yes, thank you. Thank you for the time and the time to provide comments. Thank you.
Thank you, Kavika. Appreciate your comments. Is there anybody else on Zoom? Ivalani, do we have any?
Yes, we have Kelly J.
Kelly J, are you here for item B2? Would you like to unmute yourself?
Thank you, Chair.
Oh,
This is John Helly from, can you hear me?
Yes, go ahead.
Okay, I'm just here observing on that item. I have no comment.
Okay, thank you so much. Is there anybody else on Zoom?
I have one more person who looks like he's having technical difficulties. He is with Alpha Drilling.
Alpha Drilling, is that Ray G?
Keola Talarock.
Okay.
I don't know if you want to give him a few moments to get back on.
Keola, if you can try to get connected, we'll take your testimony next. Did he submit written testimony?
He just did it.
Keola did submit, yeah.
Okay. All right.
Okay, he's not on.
Okay, all right. We have it for the record. Seeing no other public comments, I'll close public comments. Commissioners. Oh, Aurora, go ahead.
I have a question. After listening to this, I have a question for Ryan. I'm trying to remember if it came up in December, but how are we addressing that bifurcation of what happens in the designated versus non-designated? Honolulu EWS testimony reminded me, right, that what they've confront in procedure is a little bit different. And so I know there's a flow chart, but is that still, does that change with this decision?
No, again, I don't think any thing pertaining to permit approvals changes. The only thing that changes is the delegation. So I think I mentioned in this submittal that there are some, there's two sides of it, right? There's the side that wants the bifurcation because they want to be able to drill a well and to determine if, to better assess what are going to be the hydrologic impacts of pumping the well. Because you can do a Chapter 343, you can do, you can predict a Kappa-Kai analysis, you can say that, but until you pump a well, you're not going to be able to collect data that addresses those kinds of issues. So some agencies want to have the permit bifurcated so that they can drill the well first and assess. Other agencies may want to make sure that they have the well and the pump permits in hand so that they don't invest like $2 million in a well and then they can't get the pump installation permit. So what I'm proposing is flexible in allowing both of those to happen. In a water management area, clearly, to get a pump installation permit, you need a water use permit. So those things will come to the commission anyway. So I think that addresses the bifurcation in terms of like in management areas and non-management areas and our flexibility in allowing what I think people are looking for. So I hope that answers your question.
Sorry, when I said bifurcated, I kind of meant like designated, non-designated. So say I'm an applicant, my pump is less than 27 GPM. Is there a clear way that we can understand what you're proposing? Like, okay, so it's less than 27 and you're located in Waianae. Okay, well, it's going to be maybe posted on the bulletin, but it's not going to have to come before the commission. Correct. That's what this.
So Waianae is not a management area, right? That's what you're saying.
Right.
So non-management.
Yeah. So I'm thinking about it, making it easier to understand from the permit applicant side what that routing is.
I get that you want to make it easier, but it is a complex issue, right? Because if it's a non-management area, management area, is it a domestic use? Is it a non-domestic use? Is it below 27 or is it under 27? So if it's below 27 and it's for individual domestic use in a non-management area, then it's delegated approval to the chair. If it's below 27 in a non-management area and it's used for industrial water bottling, then it does come to the commission.
And so I think what's not clear, maybe, or what could be made clear is just how, this is the existing workflow and this is how the workflow will change and this is how it will improve permit processing time. Sorry, maybe you're thinking about it in terms of your workload, but I'm thinking about it in terms of like there's a lot of text, and if there is a clear diagram of the changes being suggested, I think it would be helpful. So I'm not asking for it now, but if that could be as part of the staff or tasks, like clarifying what that workflow, that modified workflow is, I think that would help in making transparent what this delegation involves. Is that, I think it's just more for like public understanding. And I know you have a lot on your time, so, but I think it would sort of front end some of the concern or questions as well.
We can do that. Yeah, we can do that.
It would certainly help my brain, so thanks.
Testimony. Oh, he closed it.
I would just say for the record, in December, when Hapuna came out, I mean, I would tell you, I was very concerned about everything being delegated, and it wasn't delegated to the chair, it was delegated to the first deputy. So when I came on board and then hearing the concerns by Jonathan Schur, Kapua Sprott about, and it was more process than it was substance. And so for me, I distinguish two things. Procedurally, it is wanting to have transparency, wanting to make sure that our process is fair and objective. And so since December to now, we've taken away the delegation to the chair and we've given it back to the board. And I think Ryan has had comments, he's consulted apparently with like the water departments, not fully with DHHL, but you did have a conversation with Jonathan that there seems to be good recommendations that have come forward. I mean, for me, some of the substantive issues are being addressed in the Kapa'akai guidelines. Because I think, and while there may be a difference of opinion with some of us on the commission, I do believe that there is a requirement for Kapa'akai analysis in everything we do. The scope of that analysis to me is determined based upon the action that's being proposed. There may be a big difference between an individual domestic well less than 27 versus a water bottling use. That I do think Kapa'akai the issues may be different, like the 343. To a certain extent, I sort of saw this as an SMA minor major. SMA minor, there is delegation to the planning director, but it fits certain categories. And I think that's what this was an attempt to do, was saying, we're going to follow the Kapa'akai guidelines. If it follows the pump installation standards, that can be delegated. I think if the two different criteria that you put under here, I also like the one that Aurora brought up, that there should be another section that says it shall not supersede any commission actions, including, for example, the Keoho set, what is it, 8 conditions that were put on there, that should apply in any cases where the board has taken action, that should not this delegation should not supersede that those either conditions should be included or brought back to the board. I also like the comment by Andrew Choi about additional forms of notice. I think even publishing an OAQC bulletin, that's probably much more widely read than perhaps our own website. I also, like us to consider, Andrew made a recommendation to amend 2 and adding F, pumps in aquifers where DHHL has a reservation. That seemed to be a reasonable. So, I mean, in my mind, procedurally, we've begun to address that. I think there is, my concern was transparency, due process. If we're addressing notice, substantively, it looks like the staff has come down with some criteria. Whether that's rulemaking, that's another question. And obviously, we're not going to be here to answer that. So, Commission, your thoughts.
I'd hate for the last action I take to be deferral, because it feels like it's kicking a can down the road. But I wonder if you're thinking that this is right for, it's the right thing to do. We need to do it right. And if we deferred, floating the idea of, should we defer so that, number one, Ryan has an opportunity to consult with DHHL. They're public trust use, beneficial use. They should have opportunity for meaningful consultation. Secondly, to consider the other ideas and recommendations that were made here today and other feedback that you received that you can add to the recommendations. Third, to really develop a workflow diagram that takes your 700 or 800 applications and kind of runs them through a chart that then shows how many drop off and how much more efficient you get, so you're going to focus on, so that the commission can see it, as Aurora has recommended. And fourth, consult with the AG on the legal process on the correct legal process for achieving these desired results.
Mm-hmm. Is that a motion?
Well, can we have comments on
Yes,
this?
Yeah, let's comment on it.
I guess I'm on the other side of the fence. And that issue of whether it's rulemaking or ministerial is here. But for me, the issue is, do we want to impede the process? If we pass and adopt what's here today as amended, we can go down the road and fix it and address it as the issues arise. And it gives time for further review, but it gives at least an authority to move and address these issues as presented and as discussed in a lot of detail. And when I first read this document, that's where it sort of came out, is it ripe for adoption? But again, the alternative is to do nothing. And again, have this issue keep rolling down the road. So I guess I'm in the camp right now is that approve it with his issues. We can address it at subsequent meetings to correct it.
I have a comment about that. I'm sort of on the other side of that. I'd like to get the legal question addressed first, because if we're doing something that is illegal rulemaking or whatever, that our actions that we take is subject for dissolution. And so I'd rather defer and seek the counsel of our.
Is there sort of clear areas where, or gray areas where we are looking at in the recommendations where it is rulemaking?
No, can I get in on this? That was a question for me too, which is, what are we talking about possible rulemaking? Is it the delegation or the
It's the except
individual?
for me, yeah, for me, it was the exceptions.
It's the exceptions?
Yeah.
I don't understand that at all. Here we are, we have had the delegation for what, 27 years? Nothing has come up about that. There were always the flexibility of the chair when he or she, and most of the time it's been a she, have had concerns about that. That was brought to the commission for us to decide. So I guess because the issue has been raised, we got to find out whether it is rulemaking or not. But from my point of view, it doesn't make any sense that this is now all of a sudden the rulemaking issue has raised its head.
Yeah. I totally agree with that, but for me, it's the public has raised this issue as well as some of the commission members. And so it is an easy fix for us to just seek the counsel of the Attorney General's office. And then we could put a period on it. It is not, it is because of these cases, these lines of cases, it is not rulemaking. And therefore you could go forward on your action. If we don't get that response, the opinion from the Attorney General's office, it'll always be a question out there whether it is or it isn't. So for me, it would be a simple question to the AG's office that they can just answer quickly, do the analysis of those cases and say what we're doing is not illegal rulemaking.
Because Kathy, in your view, what makes it, if it was just a pure delegation to the chairperson, there would be no issue. It's the rulemaking is these conditions, these exceptions.
Yeah.
So I think in the past, Larry, the delegation has just been a blanket delegation. So that's why I don't think the rulemaking issue has come up in the past, because it's been total discretion to the first deputy and the chairperson.
The issue of rulemaking would be germane only if someone challenges. If nobody says anything about it being a rulemaking, the only way that the issue would come up with someone sues the commission to say that you're doing illegal rulemaking.
But then it could potentially make us vulnerable in all of the actions that we've taken.
Wait a second though. On what actions? Is it the ones that we just routinely had delegated, or the ones that the exceptions were made? Because if it's only the exceptions that are rulemaking, it's only the exceptional cases that would be subject if the suit was successful, that said that you were doing illegal rulemaking. All the others, from what I understand the issue is, would be okay. Right? All the ones that would be routinely approved would be okay, because that's not rulemaking. But anyway, since now it's been so befuddled, how quickly can we get an answer from the Attorney General's office? Tomorrow?
Can you do subject to? Is there an option to approve this subject to review by the Attorney General?
Then that becomes a non-action because you have, because it's conditional. What does that mean then?
Yeah.
Okay.
Well, the other alternative is we could go into executive session and seek the legal advice of our attorney now.
But we're still not done. It seems to me that there's enough hesitance that we're not going to make a decision today.
We're off the hook.
So I'd rather wait till the next meeting to make a decision, even though Neil will be gone. You can have my proxy vote.
Are you gonna be gone? Are you?
No, no,
Oh,
no.
okay, you're gonna be. next
Anyway,
week.
if we can make a decision the next time around, then I'm okay with waiting 1 month. But boy, these things are so dragging. Everything we're doing now gets dragged out. You know, I thought we were a decisive commission.
Yeah, the risk of somebody suing us because you're allowing more public process seems remote. But the real risk is if somehow the actions that we take to issue permits are then tainted by this confusion, because then that affects some driller, some entity that's out there doing something that they think they have the authority to do, but then somebody questions it whether that authority was correct. It's fruit of the tainted
Well,
tree.
it just seems to me that what would logically follow if this is found to be rulemaking is that all the ones that were routinely approved would be denied because the board didn't act on it.
Yeah.
So is the legal default position that everything that comes to the commission has to be individually approved by the commission? That sounds nuts. And that we had to actually vote on each and every one of them. That's no way to run a commission.
No, you're right. And so I do think that there are framework upon which we can work the parameters, and maybe that's what the AG's office can provide us guidance on. But I think in the past, there's been no parameters. It has been a blanket delegation, and that doesn't trigger rulemaking, but it triggers, in my mind, a tremendous amount of discretion that the chairperson has or the first deputy has. And I wasn't comfortable with that either. Ryan, did you want to make a comment?
Yeah, just a comment that if rulemaking affects this decision, or maybe there's a question, should rulemaking affect the decision that was made in December of last year too? Because I think it's the same thing. And I think that maybe if rulemaking was an issue, that should have been an issue in December too. I just wanted to bring that up.
No, but the December decision was not to delegate. It was to bring everything back to the commission, right?
But there were exceptions. And I think that's where rulemaking is looking at the exceptions, right? So I think December also had exceptions to it.
I have one last question. It's not about this. It's about where's the HHL? We've been talking with Jonathan Shore just about every time we have a meeting. Is he not representing your agency?
He's in Europe.
What's that?
Jonathan does represent our agency. He is human and needs a vacation, so that's why staff is here.
That's why you're here now, but you were basically complaining that we had not consulted with DHHL. And all along, we've been talking to Jonathan. As a matter of fact, Jonathan has been very assertive about appearing before the commission. So what is your position about when DHHL gets consulted?
I think if you look at the submittal, you can see very clearly that the boards of water supplies, departments of water supplies were clearly consulted well before this action was taken, and it's documented in the submittal. We were just notified about it over the weekend through a phone call.
That's not my question. My question is then, we have to formally ask every time, and whenever Jonathan shows up, he's showing up as an individual person and not with DHHL. And the reason I ask is that I thought we've been talking with DHHL just about at every meeting.
When Jonathan appears before the commission, he will either announce that he's talking on behalf of the department or not.
Yeah, as a matter of fact, he has done that. So, okay. So what you're wanting is more inclusion in the formal process. Correct.
I think-
You just, okay, all right, thank you.
And as I understand, it's this particular item, is this agenda item.
Correct. I think there are good examples of other collaboration between commission staff and the department in other arenas.
And what?
Sorry, can I add in that the December, this commission decision specifically identified that we talk to departments of water supply and come back with a decision. So you guys identified that we needed to talk with Department of Water Supplies, which I was trying to comply with. I also recognize that I think it would have been a good idea to reach out to Jonathan. Should I have reached out to him earlier? I mean, maybe, but I did reach out to him to see if he had comments on it, and I alerted him to the submittal and wanted, him to be able to provide feedback today.
All right,
Chair,
yeah,
Keola Talarak is also on. If
Keola.
he had wanted to testify earlier and was having issues, but he's available now
Oh,
if you want.
Okay, I did close public comments, but Keola, go ahead if you wanted to provide comments.
Aloha, Chair, and Commissioners. My name is Keola Talarak. I'm the Drillings Operation Manager for Alpha Inc. I just wanted to give a perspective from the drilling contractor side, because that hasn't been presented. For your guys' meetings, you guys hold them once a month. If we can achieve 2 permits per meeting, that would only be 24 a year. To say that that wouldn't slow down the permitting process or, affect things other than, just time is what I'm trying to say, sorry, is, we're affecting more things by putting a lot of red tape than, for small wells that don't have as large of an effect. In quantity, if we have a bunch of small wells, it might have a big effect, but for how much resources we're spending to look at a well that's less than 27 gallons a minute, we could be spending that same time looking at larger wells that present possibly bigger issues. On the second hand, I also want to talk about the Kapakai analysis and developing a framework for what we need to answer. There's a bunch of questions, and it leads to things that we can't answer 100% correctly without having data. We want to be able to correctly answer these questions, but there's questions like, what kind of impact do the wells have on the environment? What kind of impact do they have on near and offshore fisheries? These are things that without data, applicants, not only drilling companies, but people going in for groundwater use permits, they'll have a really difficult time answering. So that's all I wanted to say. Thank you for letting me speak.
No, I appreciate you being here, Keola. Keola, can I ask you, what's been the difference in the permitting time from last year, December to today? How much time have you, since everything has had to come before the commission, what kind of impact that has that had on your business from December 2023 to today?
So I think it was leading up to December, there started to be a lot more regulation and discussion of what needs to be submitted with the permit applications. Prior to that, we did see closer to a 90-day turnaround once we got a confirmation that everything we have submitted has been reviewed and approved. It was closer to 90 days for people to comment, like Ahamoku and Department of Water Supply. We would see an approval or denial of a permit application. Now it's been over a year for some of our permits that are really only asking for 25 gallons a minute. Some of them are, asking for water for their livestock. Things like that, I don't necessarily feel should be given to you guys. And
Oh, we lost you. Can you unmute yourself? There you go.
sorry about that. Wells that only do 25 gallons a minute for small stuff is taking up a lot of your guys' valuable time, where we could be talking about wells that are gonna help solve greater issues like affordable and low income housing. You know, those are bigger wells that are gonna have a lot more usage coming out of them, and that's items that you guys should really be discussing and what impacts that might have versus a guy that wants water for his horses, you know. And you guys dissect things, which is very good, but I feel like we need to aim what we're dissecting. Because right now, when customers ask, when will their permit be approved? I can't give them an answer. You know, I say it has to be presented in front of the board. And then they say, okay, well, what's that schedule look like? And then I have to tell them, well, they meet once a month and we only get the agenda 6 days before the meeting. So it's very difficult for people to even have an idea of a timeline. And, you know, we've also been asked the question, can we do this without a permit? And, you know, we're not going to do that, but that's not saying someone else, you know, won't do it. And if we have people doing illegal wells, then we have no way of tracking the impacts that is happening on our aquifer, you know, and it's just for the need of water, you know. So, yeah, that's all I have.
Thank you very much, Keola. Your testimony has been very enlightening, to have real ground truthing on the impacts of our different processes. With the delegation was 90 days. Without the delegation coming to the commission, you're waiting for like about a year. Okay. Thank you, Keola. Any commissioners, any other questions? Is there anybody else, Evalani?
Possibly Carolyn Obeloa.
Okay, Carolyn. That's hopefully the last. Carolyn?
Yes, aloha, I'm here.
Okay.
I'm just here because I saw one of the non-action items about the West Maui water use Honokoi. So I'm just here to listen and learn.
Oh, thank you so much. Okay, thank you, Carolyn. All right. Okay, commissioners.
So I try my motion.
Okay.
Move we defer this matter to allow staff time to consult with DHHL on impacts and merits of the recommendations. Secondly, to consider other testimony offered here today. Third, to create and present a workflow chart in the submittal that will help us understand the flow of applications. And fourth, to consult with the AG on the legal process for achieving our desired results.
Do I have, okay, motion has been moved and seconded. All in favor, please say aye.
Aye.
Herrera? Okay, motion passes unanimously. Thank you, everybody, for that conversation. I'm going to take a 5-minute, 10-minute, 5-minute break, 5-minute break.
I'm sorry.
I know that.
Disheartened by our inaction on that.
I'm ashamed.
Thank you, Commissioner. We're back in session. Well, let's move on to item B2.
Yeah, I got some. I tried to chase you down, get you some.
I want to.
Oh, C1, C1. I'm
Oh, well,
sorry.
you must have done it perfectly.
screw
because
something
you-
up.
I got a whole bunch of them right.
Next.
I just screwed it. Okay,
Anyway.
all right. C1. Please go ahead, Katie.
Aloha Chair, Commissioners, Katie Roth with the Planning Branch, the Water Commission. Today I'm going to be doing a briefing on water reservations for the Department of Hawaiian Homelands. The idea for this briefing came about a few months ago when we got approval from the governor's office to go ahead with public hearings for water reservations on Maui and Molokai. So we thought we would take the opportunity to do just a general briefing and overview about water reservations, specifically for the DHHL and what's upcoming in terms of pending reservations, the public hearing process itself, and what the future looks like. And we have a PowerPoint as well. Next slide. So again, I'll be talking about what are water reservations, what is the process for DHHL to reserve water, existing reservations that we have on file for DHHL, pending reservations that we're currently working on, and future DHHL water needs and demands. So what are water reservations? Reservations of water are intended to be safeguarded for future use. It's essentially a set aside for water in a particular location or quantity. This applies specifically to water reservations in designated water management areas pursuant to the Water Code 174C 49D. The important point here is that anyone can actually request a reservation of water within a designated water management area, but CWRM has never approved water reservations for anyone other than DHHL. So that can be both ground and surface water. And I'll get into the differences between reservations and designated versus non-designated areas in a later slide. So water reserve for DHHL can be either ground or surface water. It's intended to provide adequate amounts of water for both current and foreseeable needs. Foreseeable, we tend to think about that in terms of the planning horizon of 20 years, but we do acknowledge that those needs for water extend beyond that, and that the needs may need to be adjusted in the future by the Commission. A reservation is not immediate access to wet water. We consider most of these reservations currently to be paper water. So they're essentially a reservation, a need for water that's articulated, that's either on the books in an admin rule or we have on file. That doesn't mean that because a reservation is approved that the water is available for use. Usually there's infrastructure requirements needed. Maybe DHHL needs to drill a well or have a conversation with the county about how to actually convey water to homestead lands. The courts recognize that there's 4 public trust uses of water. Water for DHHL, of course, is one of those. So when making decisions about water allocations, the Commission has a duty to protect public trust uses of water, including those for DHHL. Next slide. So in designated water management areas, reservations are made through the rulemaking process. I'm again citing 174C 49D of the code. Those reservations are subject to periodic review and revision. We also have our admin rules, 171 of HAR, which further articulates the rulemaking process as it relates to water reservations. In non-designated areas, reservations are established through Commission action. And in non-designated areas, that's specific to DHHL only. So no other entity other than DHHL can have a reservation of water in a non-designated area. Next slide. So what triggers the conversation for a water reservation in the context of DHHL? Sometimes those requests come to us through a formally written petition for a water reservation. Sometimes they're included in a staff submittal as part of a larger Commission action. They can be discussed and done in conjunction with the setting of IIFS, so in collaboration with Aaron and the process he goes through. They can also be discussed in connection with the water leasing process, which is not a function of the Commission, but resides within our land division, and that's HRS 171-58G. We are in the process of developing a reservation page on our website, which would have an actual formal petition form available. When drafting this briefing, I came to the realization that we actually don't have that form available publicly on our website, and that's something that we want to change, in addition to having more detailed information about water reservations on our website. Ultimately, often these reservations are done more ad hoc. When there's an action that may affect DHHL water needs, we'll have the conversation with them about what that looks like. Next slide. In terms of groundwater reservations, reservation requests are considered under the remaining sustainable yield for a particular aquifer. In designated areas, staff will consider the DHHL reservations when they're reviewing water use permit applications. In non-designated areas, we don't have a formal process to ensure that a new permit will not impact a DHHL reservation. When talking to groundwater staff, it's my understanding that that's largely because pump size and capacity, there's not like a specific allocation amount attached to those well construction and pump installation permits. So it's a little bit more challenging to understand what the actual amount of water and compare that to a DHHL reservation amount within that particular area. But as Andrew mentioned in his previous testimony, one way we could address that is by taking well construction and pump installation permits in areas where DHHL has a reservation. We could be bringing those before the commission. And then a quick note that in some cases, in terms of groundwater, a reservation could trigger the designation process if that reservation leads to the exceedance of sustainable yield. In terms of surface water reservations, they're typically, again, made in connection with the setting of interim in-stream flow for a particular stream. In cases where there is already an IIFS established, the commission may have to adjust the amount to account for DHHL needs and other public trust uses of water. In the case of surface water as well, the setting of IIFS and/or a request for water reservation could also trigger designation.
Can I interrupt you for a second?
Yeah.
That last point may have to adjust the IFS. Stream water is a resource, and that's a public trust purpose. So are you saying, from your standpoint, that DHHL has superior rights than the stream itself?
Maybe I'll defer that to Aaron if he wants to comment a little bit more about his process when establishing.
Oh, you can answer that later. I just wanted to interrupt you.
Okay. Do you want to answer it now or later?
When we get into the discussion.
Okay.
Might include the other public trust purposes too.
Where can you find information about water reservations? They can be found in a variety of places, which again, we're trying to make a little bit easier to understand by putting them on our website in one specific area. But currently you can look at our admin rules, chapter 171. If you scroll all the way to the bottom, it will have the list of existing water reservations that have been done through rulemaking. Again, that's specific to reservations in designated water management areas. Next slide. You can also find information about reservations in the State Water Projects Plan, which is one of the 5 components of the Hawaii Water Plan. This plan inventories existing and future water needs for state projects, including those of DHHL. I think there was a process in 2018 where DHHL projects were updated specifically for the State Water Projects Plan. And then the entire plan itself was updated again in 2020, but it accounted for the update with just the DHHL projects. This plan is generally updated every 5 years, and commission staff will refer to it when reviewing requests for DHHL water reservations, just to ensure that there's some consistency with plans that have been approved and the reservation request and amount. You can also find information about all approved reservations in both designated and non-designated areas in the Water Resources Protection Plan, another component of the Hawaii Water Plan. This inventory is all approved DHHL reservations. It's also generally updated every 5 years. Next slide. The county water use and development plans should also reflect DHHL water needs. The Water Resource Bulletin has a section about water reservations. I think this last month was the first time we deleted some old reservation requests that had been on there for many, many years that weren't being acted upon, not just DHHL requests, but other entities. We're going to, again, provide more information about reservations on the website. And then DHHL also has island and regional plans that should include information about future reservation needs. Next slide. This is the current list of existing DHHL water reservations. I'm going to have more detailed slides for each island later, but it gives you some idea about what reservations currently exist. Only 5 reservations were made before 2018, so there's a big push in 2018 to get more reservations through. DHHL estimates that they have about 15% of the reservation needed. This amount is reflected in basically paper water that has been secured. It doesn't reflect the full need that they have, but I thought it was important to mention that while reservations exist for most DHHL lands, they only account for about 15% of the actual water need. Next slide. Again, a few months ago, we got approval from the governor's office to conduct public hearings for water reservations on Maui and Molokai. That is here in this list. There is a question about whether or not Ualapu'e will be included in that public hearing process, and we're having discussions with DHHL about that currently. This is just a broad overview of the steps involved in rulemaking. As you're probably aware, it's a very lengthy process. So we're at step 7, conduct public hearings. And just for timeline purposes, it took us about a year to get to this stage from initiation. So it's not a quick process, unfortunately, when you have to go through rulemaking to establish reservations. Here are more detailed, next slide. More detailed maps for each island, showing you where we have reservations. I'll flip through these kind of quickly. Next slide. Highlighted in green are the reservations which will be part of the upcoming public hearing process. Next slide. Next slide. Kuala should actually be highlighted here, but it's not. That reservation amount is actually being lowered slightly, and that should be part of our public hearing process. Next slide. Interesting, there hasn't been a reservation on Oahu since 1994. It's kind of interesting. There's definitely more of a need according to DHHL, but for a variety of reasons, which they could get into, they haven't petitioned for additional reservations at this point. Next slide. Hawaii. Next slide. So getting into DHHL future demands, there are reservations in process for East Maui and Waikoloa on Hawaii Island. Both of those are surface water. Future demands, we are having ongoing conversations with DHHL. Again, this briefing kind of kickstarted the need for more conversation with that agency. So I've been talking to Andrew and others about setting up maybe quarterly meetings with them to talk through not just reservations, but other DHHL issues that we may need to interface on. Some of the big challenges for DHHL, which you may be aware of, infrastructure, who pays for that infrastructure? You can get a reservation on paper, but how do you actually convey the water to homestead areas? Who has a duty to provide for that infrastructure? Should it be a shared kuleana? Is it DHHL's responsibility, the commission, the county? There's a lot of conversations that need to happen about that, but that's one of the challenges for sure faced by DHHL. There also needs to be better coordination among agencies, including CWIRM. Where do we actually locate reservations in areas that make the most sense? Maybe there's homestead land in one particular aquifer or hydrologic unit area, but the actual water itself, the well, maybe the county well, is in an adjacent aquifer. So does the reservation need to be for that adjacent aquifer, or should it be water reserved within the aquifer where the homestead lands actually exist? And then in areas where we have limited water availability, we need to be a little bit more proactive in thinking about and having the conversation with DHHL about what their needs are, prior to making other decisions about water allocations. especially when other water use permits and other permits are coming before the commission, just because there isn't a reservation on the books, we still need to have that conversation about what the needs look like for DHHL. And again, an acknowledgement that water needs do extend beyond that 20-year planning horizon. And with that, that concludes our briefing and presentation. Staff are available to answer any questions, and we also have staff from DHHL as well.
Thank you very much, Katie. Commissioners, questions? No.
Can they answer my question? No?
Aaron?
Morning, Commissioners. Aaron Stark from Stream Protection and Management Branch. The modification of an IIFS in the balancing of non-in-stream uses might be needed to accommodate a reservation or a use for DHHL as a public trust use. One example would be the 2018 decision in order for Navaeha sets an IIFS North Waihu as natural flow. At the time, DHHL was not a party to the Navaeha contested case, and their potential non-in-stream usage was not considered in the decision. But they have lands in Waihu that could potentially utilize non-potable water. So we might need to modify the North Waihu IIFS to accommodate those uses.
But I'm talking about cases where usually when we set an IFS, it's been my experience that we basically set it at the minimum that allows viable stream life, not way above it. So in a case where the IFS is at a level that any lowering of it all would harm the stream, are you saying that from your standpoint, we have to do that?
I'm not making a blanket statement across all IIFSs, and in actuality, I don't think most IIFSs have been the minimum. They've been above the minimum.
So what would happen then if you have a DHHL reservation request, which is reasonable, but it takes off more from the stream than what would be the minimal viability?
That would be a balancing that would need to, the commission would need to make. The stream is not more important as compared to DHHL, it's equally important as DHHL.
So, but yeah, so, okay, so what is the compromise? See, the reason I ask is that there have been some dicta by the Supreme Court that said there may be instances where you have to destroy the resource to accommodate uses. Never went beyond that to say, well, how do you decide that? Okay, but in this case, there will come time because the DHHL is finally getting enough lands to be used, especially in rural areas where they don't have access to like a public water supply system. They have to put in their own. So there's going to be a time that we have to decide. But from my standpoint, if you take a stream, if we're talking about if you take a stream below viability, that's destroying the stream. So it seems to me, from my standpoint, you can only draw enough water for off-stream uses, including DHHL, where it does not affect the stream viability. Now, obviously, the obvious answer is that other users get their water taken away for DHHL because DHHL is a public trust purpose. I think that also when in the current water management areas, if you have unused or unpermitted access in a particular aquifer or in a stream area, and DHHL gets a reservation, that amount of water gets taken off about what is available for other permits, right? That's what happens.
If you may allow me to comment, the history behind stream versions and the IIFS has been that the construction of the dam essentially took all but the high flows. I would assume, and we would probably make the recommendation design to meet say a DHHL need or any other need would not be so destructive to the stream to completely drain it or completely remove all but the high flows, such that even if we lowered an IIFS to say the 64% of medium base flow, which is kind of been accepted as like that minimum that you're talking about, there is still opportunity to provide for the flushing of larvae or nutrients or sediment or coarse woody debris, to provide for the habitat, to keep the riffles and runs flowing, so that we have migratory pathways maintained, so that we have the other in-stream values, not just Oku and Opie and Evi, but the recreational needs are met, the downstream uses are maintained, the nearshore impacts are preserved, so that I think we can find a balance where the stream is protected and the DHHL needs are met.
Wait a second, though. You cannot meet all of DHHL's needs if you have those minimal requirements for continued stream flow. So something has to give up. DHHL cannot get everything that they want in a particular.
I think it would be
except at the cost of other off-stream users.
On a case-by-case basis with sufficient storage. I mean, DHHL is not going to start a sugar plantation. I mean, I think there is some way forward that meets all needs. In some cases,
I absolutely disagree with that. You can't have everything for everybody.
not everybody. Just I'm talking about.
I understand that. What I'm saying is that we're not dealing with really huge rivers in Hawaii. We're dealing with fairly small streams. Okay, so if say you're having an off-stream use, even those in non-management areas that have riparian or pertinent rights. No, pertinent rights is a little different because they're also sort of a public trust purpose. You're going to have to come to a time where you cannot say that one public trust purpose has absolute priority over the other. So I don't think that you can get to a case. What my preference, I don't know if that's it's a legal preference. My preference would we still have to maintain minimal viable stream flows at the cost of the DHHL getting all the water that they want. But we're going to get a case like that eventually.
I think it'll come to things like climate change and the severity of, say, drought conditions and the length of those drought conditions. Yes, maybe there are other everything's going to be affected.
Even without those changes, as DHHL is able to provide their beneficiaries homesteads and increase water, you'll get to a point where the amount of water available is not going to be enough, even in aquifers.
Yeah. Asking another way, if I might, you said that CWRM has never approved reservations for other than DHHL, and that may be the case. Can we make reservations for other public trust uses?
My understanding is yes.
Okay, it just hasn't been done yet.
Can I interrupt on that? Because let me say, is Barry still around? I think a long time ago, I told Barry, why don't you guys ask for reservations for the public water systems so that you don't have to be competing with private people all the time. So it is a possibility.
Exactly. That's correct. For household use, for the rest of the public, if you will. Right. That's exactly right.
I have Neil and then Aurora.
Back to your earlier point, Larry, in my 8 years on the commission, we never tried to give everybody everything they wanted. We tried to balance as best we could. And would you agree that the East Maui contested case discussion might be relevant here, where every stream was different. Some streams were highly compromised and so forth, and those we put a minimal wetted pathway. Other streams, were really heavy kalo users and so forth, and we treated those, made sure they had enough for their public trust uses. And then we withdrew what we could to get to DHHL lands and so forth, but it was a balancing, very much a balancing act. And yeah, we don't, and especially now with DHHL's additional infusion, much needed infusion of cash that'll allow more development. I'm really keen to hear how that's going to change their reservation needs in the future, because we got to rejigger, we got to rebalance again.
Yeah. Let me ask
Now
you-
this is just stream. Now ground is a whole different issue, and much of their needs will be supplied by groundwater, I assume. But when it comes to streams, it really is a challenging balancing.
I've got Aurora, and then I'm going to take Paul. Aurora?
Well, Paul, if you have a comment on that, go ahead. I'll
Oh, thank you. This was a follow-up question. We asked whether we can make reservations. Do you think we have a duty to make reservations for other people for future needs who are public trust users?
I don't know if I would comment on, without, I mean, that's maybe a legal.
Well, you said we have a
question.
duty to DHHL
We
with
have a duty,
respect
I
to their
mean, I-
request for
so
reservations.
my question relates.
We have a
to
duty
this.
to take into account the needs of other public trust users. That's the question. Maybe that's a question for the AG.
So I think my question relates to this, and I'll just say it's a bit of a red herring to like frame like other people, but DHHL has a particular status, correct? I mean, Katie, can you run down the history of that ruling? I mean, my understanding is DHHL has this, I guess, level of priority because of conditions of statehood. And this is somewhat analogous to the Winters Doctrine, right? In the US, where Navajo have rights of prior appropriation. Do you have that background, Katie?
Maybe I would defer to Andrew and DHHL staff to come up and
Yeah.
comment on that.
Okay. Good, Andrew, if you can introduce yourself again.
Aloha, Andrew Choi, representing the Department of Hawaiian Homelands. Thank you for the question, Commissioner Kagawa. The department has a unique history. As you folks know, it was established by Congress in 1921, adopted by the full Congress back then. It was administered by the territory of Hawaii up until statehood. Now, when Hawaii was admitted to the US through the Admissions Act, one of the conditions of the Admissions Act was that the state would take on the responsibility of carrying out the Hawaiian Homes Commission Act as a condition of statehood. So that is one statutory authority. The Hawaiian Homes Commission Act was thus incorporated into the state of Hawaii's constitution. Its water rights are articulated as part of the state's constitution. It's also identified specifically in the water code as, and also further validated by Supreme Court rulings as a public purpose use of water. I don't know if that I answered your question, Commissioner.
Yeah, I think it does, because I think without understanding some of that legal context, we can, I guess it gets uncomfortably police focused. And I think what we want to do is stay on what the commission's responsibility to the, I guess, to the statutes is. So I wanted to get back to Katie's presentation and understand. So DHHL has this privilege in designated and non-designated areas. Some of it's unexercised, much of it is paper water. What are the implications for the matters coming before us? I know we've had the Waimea watershed matter, which is gonna be the next action item. There are these proposals for Maui and Molokai, which are everyone's gonna have their claim. And DHHL being one of them, that needs to be balanced a little bit differently than multiple permittees. Am I understanding that correctly? Is that the way we should be thinking about it from your perspective?
Can you just re-articulate the specific question you have? Is it about?
Mostly I'm trying to mirror back that I'm understanding kind of what we need to take away from this presentation. That we need to understand that DHHL has this particular ability to make reservations in both designated and undesignated areas, and that we need to factor it in. And so, but it's not, DHHL is not just another permit applicant, right? And so how do we as commissioners need to be weighting things? And I think that's some of what the other commissioners have been trying to get at.
Yeah, I think you're absolutely correct. So I think one of the major takeaways from this presentation, like you said, DHHL as one public trust use of water does have priority. How we figure out a way to balance that with other both public trust uses of water and other reasonable and beneficial uses of water is something that needs to be discussed and will come up more as we see less water availability in certain areas, impacts of climate change, what have you. The presentation also mentions, that DHHL has approximately 15% of paper water, but there's more needed. So you're right that there is going to need to be more conversations about what those needs look like and ways that we can better collaborate not only with DHHL, but with the counties to better understand how we can, if maybe the county has the ability to provide water to DHHL, how we, spread out that duty of not just the infrastructure to make sure that DHHL uses have adequate supplies. Does that kind of answer your question or get at kind of the context of the presentation?
I think so. And I think I want to have a little bit, since it's an informational briefing, not action item. I mean, Erin, you've brought up, sorry, let me back up. When I started on the commission in 2021, we were talking about Molokai and Maui, and there were some interesting proposals that I remember DHHL bringing up about that were a bit more holistic than the normal permit applicant, about their investment, the recognition of scarce water, their investment in, their interest in investing also in watershed protection. Like what, maybe this is for Erin, I don't view things as just a zero-sum game. Some things are mass balanced, but there's also room for innovation. And I think some of that conversation had come up on Maui. I remember Commissioner Meyer brought up R1 and R1's uses coming up again. How do we slice the pie in equitable ways, but also try and innovate and expand or conserve? Like, what are the things? Sure, we deal with permits and allocation, but what are the things we can also be supporting as a commission as we think about the needs that are outstripping, supply? So, I mean, Erin, maybe can you remind us again, like where are the spaces where we need to focus some energy and attention as we?
Well, I will just comment about, so DHHL has a reservation on the Big Island from Mahukona Aquifer System, but they have broader regional needs that can't just be met from the one aquifer. And in examining or in developing an interim in-stream flow standard for Waikoloa, for example, the South Kohala drinking water system, which diverts almost the entirety of Kohakohau and Waikoloa streams to provide for drinking water supply, that water supply, the county's water system, could be used to meet potable needs that may have originally been met with a reservation from groundwater. So this is where we are considering protecting, establishing an in-stream flow standard to protect in-stream values, but then there are also other public trust uses that could be met or should be met with waters from this same water essentially, or sourced from the same source. Especially since the stream diversions that feed the system are on DHHL land. So it's kind of a little bit full circle in that the resources that could be used to meet DHHL's needs should be in the consideration of the establishment of an action to protect the resource. I don't know if that answers your question or not, but
Go ahead, Larry.
I want to remind commission members that another public trust purpose is domestic uses of the general public. That's never been tested. I assume that means public water supply systems, but public water supply systems also provide agriculture and industrial uses. So that's going to be a really thorny question about what part of that is a part of this.
And water to Hawaiian Homes as well.
I'm sorry?
And water to Hawaiian Homes
Oh, yeah,
beneficiaries as well.
yeah,
Absolutely.
sure.
They sure that they're part of the public.
Yeah, all I'm saying is that aside from the DHHL reservations, public use, domestic uses of the general public is an equal public, as is the resource itself. So down the road, none of us will be around, but that's going to bump heads, and we're going to have to come to some kind of compromise about us. Not everybody can get all the water they want, and particularly on the streams, not all streams are going to have to be kept. Now, aquifers are a different question. You get beyond the sustainable yield, and you start to permanently destroy the aquifer. So that's going to be a different issue.
Right. I'd like to ask again, do we have a duty to make reservations for other public trust users? And you said you didn't know. Could you find an answer to that question? Could you research that? I mean, I'm not sure the commissioners have time to do that and the resource of the.
And I can reframe my response. I don't think it's accurate to say I don't know. I think that there is a duty to public trust uses of water.
I see.
And to find a reasonable, when we have to balance reasonable and beneficial use as well. I think that there's a lot more to say on that topic, and that's definitely something that if you want us to investigate, we can definitely do that to come up with a more formal opinion, if that's something that the commission is interested in.
I think it'd be very helpful if you could characterize that for us and get a comprehensive opinion in that respect, because as Larry said, it's going to come up and it's going to come at us four square at some point with respect to surface water and groundwater as well. Further, you mentioned that 15% of DHHL's needs are being met by current reservations, if I have that correct. Where does that number come from?
So that 15% is reflected in what we would consider paper water. Not all of that is what we would call wet water. And I could maybe defer to Andrew again to provide more details.
You don't know where the numbers came. You didn't prepare that number yourself.
Provided by DHHL.
Oh, I see. Okay, it's from DHHL. Okay,
I
gotcha.
think,
You answered that question for me. Thank you.
Go ahead, Andrew, if you wanted to explain, since that number came from you guys.
When we calculate our reservation request to the Water Commission, it's really based off of our island plans. As you folks know, the Hawaiian Homes Commission has exclusive land use authority over Hawaiian homelands. Our island plans articulate our commission's land use policy for our land. So are we going to use it for residential? Are we going to use it for ag? Are we going to use it for commercial? So our water reservations are based in large part on our island plans. We've made reservations for portions of our lands, but not all of our lands. So that's where that number came from.
Yeah, in calculating that number, it's interesting. It's kind of a gross number and nebulous. Were other sources considered in looking at that only 15% being available in terms of the public water systems that are available, public utilities and that sort of thing, which is where the majority of Hawaiian homeless beneficiaries get their water today? Or was that ignored and just saying, okay, well, you need that, the reservation just as an estimate of the total quantity of water that DHHL beneficiaries will need going forward? Do you know?
If I understand your question correctly, I believe the water code says that our reservations are for both current and future needs of water. When we designate our lands for residential, it's normally based off of the usual county municipal standards of 600 gallons per lot per day. So we will designate, say, 10 acres for residential, and we'll do a back of the order envelope calculation of how many lots at, say, 5,000 square feet or 75,000 square feet that we can get from that area. And that's what we base our estimate.
I understand, but I'm talking about where's it coming from? What's the source? Did you assume that any of that would come from the public utility or public source, county sources, if you will?
I think in certain locations where the county system is within close proximity to our lands, then the assumption is we will try to work with the municipality.
Do you know? For sure. Is that taken into account in the 15% or not?
Do we know for sure if the county has?
In other words, does the 15% assume that the other public sources would be providing water to DHHL properties?
And when we calculate our reservations, it's based on what is needed for homesteading.
I understand. Okay. What you're saying is it doesn't. Yeah.
Yes, that's your responsibility as the Water Commission.
I hear you. Okay, thanks.
Angie, when you say it's based upon your water plans, is there the island plan? So is there, what's the time frame? Is that when you're ready to build? Is that when you, because we say water code says present and future. So what is your time frame?
That's an excellent question. Our island plans per our administrative rule is a 20-year outlook on what we can or hopefully can develop, assuming that we receive sufficient funding for our developments.
So are the reservations based upon, I guess, a future estimate up to 20 years?
Yes, because it's based on our island plans, and our island plans have a 20-year outlook.
So when we have to make, and I guess this is water staff. So when we have to make the hard questions about water allocations, so we take their reservations as is, whether they are ready to build or not. Okay. Do we distinguish between whether it's DHHL residential use or DHHL industrial commercial use? Is there a distinction? Is it just if DHHL's reservations, we take them as a whole, or do we distinguish the types of use as we would, for example, public trust?
Their calculation is dependent on their land use plans, and then, just comes up with a number. We don't make that decision.
Okay, so we take it as DHHL reservations. But Andrew, do you guys distinguish when you submit to us? Is it difference between domestic and commercial?
We do try to identify for the commission staff what our reservation amount is based off of. And again, that's per our land uses. So we do distinguish our residential demand, our agricultural demand, our commercial demand. The reservations that we have submitted to the Water Commission to date have been primarily for our homesteading purposes, either residential, agriculture, or pastoral.
And there's a comment I think that you made that, well, maybe I should ask the question. Who pays for the water infrastructure? Who pays for the delivery of water?
I think that is a question that we would like to know the answer as well. I think, anecdotally, we've had some good working relationships with the various counties of water supply. We continue to have dynamic conversations with them on how to fulfill the obligation of the Hawaiian Homes Commission Act as a responsibility of the entire state, not just the Hawaiian Homelands Department. We do feel that there is some level of collaboration and contribution needed from all parties. What that looks like, I think, is on a case-by-case basis.
Because do you include the cost of infrastructure when you're doing your development plans? Is the cost of developing a water infrastructure system part of your Cost estimate, okay.
Yes, when we develop our cost estimates, it's both for on-site and off-site infrastructure.
That's great, okay.
Chairman.
Yes, please.
That's really a good point. This is all about collaboration, working together and sharing. Absolutely.
Hi, Andrew. I guess to help sharpen Commissioner Meyer's question is that if the water supply for your development is coming from a public water utility, are you then sort of double dipping or double accounting for that water? Because the public Department of Water has a supply plan or demand plan. You are submitting a water demand plan as well.
I think to the
I mean, you don't need to
Yeah,
answer
no,
that right away, but
yeah, yeah.
as you start getting into your development to, again, identify that to help us, help planning, not to double account for the water.
I think, thanks for that question, Commissioner Katayama. We have been a lot more progressive and proactive in trying to reach out to the county Department of Water Supplies to make sure that their water use development plan is inclusive of our water developments. A great example is actually on the Hawaii County Department of Water Supply. They've worked really well with us in trying to outreach to our beneficiaries. They sat down with us and they went through the effort of planning meetings specifically for our beneficiaries to make sure that their input is included in their water use and development plan.
Good.
That's great.
And I think, we'll get smarter and sharpen our focus on these things. And Katie, thank you very much for your presentation. And it really helped me zero in on specific statute on how water reservations are made.
Yeah.
One sort of comment is that you identified several different water plans from resources, projects. And if you were to look at the dates of when those plans were adopted, you find a sort of a long period. And I guess my question is there a way to better synchronize the plans? Because it seems that we're dependent on a lot of these plans, from the county water use and development plan to the water protection plan. I mean, all of these should be used and living plans. And some of these things are like 10 years old.
That is a requirement. It just doesn't get done on a timely basis.
I mean, so is there a process that do a better synchronization of these plans?
It's definitely a comment we've heard before in terms of the updates to these various components of the Hawaii Water Plan and how to get them more in sync, because as you mentioned, they should be communicating with one another and they're being referenced by each other, right? And if you have
That's
one
how decisions are being made by each of them.
Exactly. So as part of our update to the Hawaii Water Plan framework, which I know we are a little delinquent in getting before you, that is something that we hope to address in that framework document to provide better guidance on how we do
The
it.
process is
You need a conductor.
Yes.
Overall. Do a better job.
Any other questions? Oh.
Yeah, I think I remember that cascade of planning that gets done, and it's like painting the Golden Gate Bridge. By the time you get to the end of it, you got to go back because the first part of it all changed.
And the last piece is always the timing piece.
Falls off.
It's a really it's a challenge. It's
Yeah.
a challenge, but I know you folks do your best. And well, what I'm hearing though is that you do your plans for 20-year horizon, and so the new infusion, which is a Sentinel event of 600 million and so forth, that your chair is trying to leverage like crazy, is not changing what I think you guys came in 2018, and we did your reservations on the basis of your current and foreseeable needs at 2018. So that is fairly unchanged by the new event of having more money, or now you just have some money to implement more of the plans that you had,
Or are you accelerating your plan?
Thank you for the question. I think it's a combination of both. It's accelerating the lands that we already have. To your point, our chairman has been very adamant about looking at adding new lands to our inventory, lands that are not far and remote, like the original lands that we did receive. He's been looking to look at lands closer to infrastructure so that we can connect to the counties. So to your point, like my colleagues in planning, we do update our plans on a regular basis as well. We do have our own cascading diagram of our planning system, but our island plans are due for an update. Our Hawaii Island Plan was adopted by our commission in 2002, and we're currently going through that planning process to update it, including the new acquisitions that the department is acquiring on that particular island. We'll go through a similar process for all of our islands, including the new acquisitions that the recent $600 million gift from the legislature has allowed us to acquire new lands across the state.
I would avoid using the word gift because it goes back to
obligation.
Commissioner Kagawa Viviani's point. And it would be, I think it'd serve this commission well to have a discussion of where that trust relationship comes from. And I think we all have certain assumptions and certain knowledge, but there's a history here of obligation, not just it's nice or it's a concession to the host culture and so forth. There are obligations made. So as you, and I appreciate going back to the question of double dipping and so forth, the chair now has been really kind of thoughtful about by getting infill parcels, like the one in Kailua that was just acquired, and Waipoli on Kauai and so forth, near existing infrastructure. So in that case, you don't double dip and have a reservation for that and then draw your resource from the county system. It's drawn from the county system and is not covered included in the reservation. I didn't ask that very clearly, but
I think I'm going back to the point in Katie's presentation about what a reservation is. It's simply a acknowledgement that in certain aquifers or in certain surface water management areas that the department will require a certain amount of water. How that water gets conveyed to the DHHL lands, the reservation doesn't touch that. It just simply says that Water Commission acknowledges and reserves this water for the use of Hawaiian homelands. We still have to have conversations about how that how we get wet water to Hawaiian homelands. So that's oftentimes in current practice done through conversations with Department of Water Supplies, through water development agreements, in other far remote areas with private water system owners. It's also should be noted, we do own and operate 4 water systems, our largest being on Molokai, where we service about 400 customers, and we also service the customers off of Hawaiian homelands like the airport, the high school. So we much rather prefer to work with County Department of Water Supplies to provide service to our areas, as through our own experience, owning and operating a water system is a very challenging task. Yeah,
not your core business.
Correct.
But of the reservations we have in place, how much of that is paper water, did you say?
Oh, that's a good question. We'll have to look at how many places where our reservations have been converted to wet water.
I think it'd be good information to have. I mean, and just it speaks to the challenge of fulfilling the mission of the Hawaiian Homes Trust, that the lands set aside to fulfill that were generally remote and without infrastructure. So we're supposed to put Hawaiians on homes, but then we have to pay all the costs of developing the infrastructure, except for Kali's new strategies of let's go where the infrastructure is and acquire land that may not have come to us in the original trust. So that's why it's so long delayed, that it takes, forever to kind of get utilize the reservations we put aside from you, because you're out in Ka'u, or you're out in some remote area.
So maybe that does need to be part of the conversation earlier on when we make these reservation requests come before us, is to think more holistically about where the water actually will be coming from.
Good point.
Yes, please, Larry.
There is a mechanism for addressing the double dipping. Say that DHHL has a reservation for X amount of water, and then over the years, part of that is being satisfied by public water systems. When you get to a point where you've maxed out the use, at least on paper, the commission will be starting to look at the actual allocation and uses of the permits in a particular area. And we have the authority to reduce and reallocate. So at that point in time, DHHL will say, well, 30% of our reservation is being met by public water systems. So why don't you just reduce our reservation by that amount? Or at least if you resist, we can do it. But it harms nobody to keep that reservation when part of it is being met by public water systems. And the issue only comes up when we're bumped up against the limit. So I don't see a problem with a potential double dipping. One last comment is that your current head, Kali Watson, it's come full circle. He was in the cabinet when I was on the cabinet.
I asked him the other day, were you on board? He said he was in high school.
26 years ago. And he's still going. He must have been a very young man when he was with me.
Any other questions? Anybody in the boardroom having a question? Is there anybody on Zoom? Okay, with that, thank you so very much, Katie. Thank you. Thank you, Andrew.
Thank you,
Appreciate
Katie.
you being here. That was a very helpful presentation. Non-action item, we'll move on to item C2.
Still morning. Good morning, Commissioner.
It is still morning. Quickly.
Yeah, 6 minutes.
Just want to provide let me make sure everyone's
Everyone's in the room.
Mhm.
For Mike to connect.
We can't hear anything.
Thank you. I can't hear anything either.
Okay, go ahead, Dean.
So yeah, just wanted to provide you folks a real quick update on the status of the stream diversion works permit application that was originally brought to you folks back in January of 2024. So the last time we met with the group, the Waimea mediation group, was on May 29th. And so at that time, I know under the direction of the commission at the last meeting was to go back and kind of get if KIUC, Kauai Island Utility Cooperative, could get a cost estimate so that we're comparing apples to apples as far as the two project proposals between Kekaha Agriculture Association and KIUC. And so at the last meeting that we met on May 29th, basically KIUC was still in the process of getting cost estimates, recognizing whether it be supply chain issues, consultant firms and all that. So our next meeting currently is scheduled for Monday, July 8th, hopefully in time to bring a submittal to you folks at the July commission meeting. However, I know Don Huff did reach out to me from KIUC that they do have a schedule. Her and Jordan, Fuku do have a scheduling conflict, and so we do need to figure out a time to meet again. Unfortunately, I'll be on vacation that week as well, but we'll figure something out. So you leave it up to the mediation, the parties, if they have any other comments.
The first step in that, I think we identified 3 steps to this. That number one, let's agree on the scope before we go out and costs. It seemed like there were a little different ideas on what the scope of the project would be. So have we got that nailed down?
No, not at this point. I think part of it was getting the cost and figuring out.
Don't you want to do the scope before the cost?
I think to be able to pick and choose, I can't recall the discussion that we had, but in order to
the scope of what's required to fulfill the obligations of the mediation agreement, then secondly, the cost of that, and then third, since we were considering an in lieu payment by KIUC, then a determination of how you best use that money, the monies that you have from KIUC and any other sources. So I thought the first thing was the scope of work required to fulfill the terms of the agreement that they all have together.
Yeah, sorry, I can't recall the discussion. Maybe if any of the parties want to jump in.
Because my understanding was, you're right, it was identifying the scope, but it sounded almost like KIUC might have been willing to do more. Or I think they wanted to see sort of the Cadillac version versus the minimum. And so maybe if the Cadillac version was something that they could afford, then they wanted to know the cost of that to determine what would be the section. I may be wrong.
Well, Cadillac, I mean, we talked about, originally there was contemplated a phase 1 and a phase 2. And the phase 1 was really done in anticipation that there would be a phase 2, but now there's not going to be a phase 2. So we said, okay, we got to go back and figure out what is essential, what it was planned here that was agreed upon, because that then can be costed so that you can develop a dollar number, that then KIUC is considering to contribute to then a whole new capital improvement plan, because we've agreed that just doing a phase 1 as originally contemplated it may not be optimal. The phase 1 made sense in the context of there being a follow-on phase 2. But if you're not going to have the phase 2, then you might use the money differently. But you got to figure out how much money, and the money goes back to the agreement, which was the phase 1. So you got to get that before you can get the money. Then you can redesign with that money, the best system for now.
Dawn, did you want to say something?
Yes, aloha, Chair. Thank you. I just wanted to clarify. We have been, we understood the 3 steps as you described them, with the scope being the first step. From our perspective, the scope is the 2018 plan that everyone reviewed and approved. That is the scope for KIUC's commitment here from our perspective. I won't speak for anybody else, any of the other parties on that, but that is what we are working on, getting a cost estimate for, a current cost estimate for. And once we have that, then we can follow up with the other working parties and the commission. But I do also want to clarify for the record, we are not open to expanding our scope beyond what was reviewed and approved. That is the limit of what we are willing to do. That was our commitment.
Okay, that's clear. Okay, that's helpful, Don. Did anybody of the other parties want to add anything? Nobody. Raise your hand if you'd like to say something. If not, I'm going to take Don's comments. I don't see any hands coming up. Okay. Commissioners, do you have anything else you want to ask or add? So so we're looking now at the July meeting?
Correct.
Okay. All right.
You'll make it happen.
We'll try very hard.
In spite of all the vacations.
And Don, and there's a commitment by KIUC to have complete the scope and the cost estimate, Don?
We are working on it. We do have conflicts with the currently scheduled working group meeting in July, as well as the commission meeting in July. So I will have to work with Dean on some dates.
Okay.
On when we can get back to you, and you know, once we have the cost estimates, then we can follow up on the timing piece. But in the interim, I will check with Dean on some optional other options for dates to meet with the working group parties at least.
Okay. All right. Seeing no other questions or comments, this is just information. Thank you for the update. We will close item C2 and move on to item C.
Please check if anybody's offering public testimony.
Is anybody offering public testimony either in the room or on Zoom? Very good.
This will be my last time I see the West Hawaii folks. Aloha, I wish you well. I hope this gets resolved.
There you go. Thank you very much. All right, we'll close item C2 and move on to item C3.
We have a couple people in the waiting room, so
okay.
Wait, give it a minute. All right. Good afternoon, commissioners. This is agenda item C3. Let me just get the presentation up on the screen. So it was brought to our attention recently that there was a housing development in West Maui, Pu'ukoli'i village, which recently came before the Land Use Commission. And in that meeting, in the article by Patricia Tummins of Environment Hawaii, it was essentially what the commission was pointing blame for delays in the development of Pu'ukoli'i.
Land Use Commission.
The Land Use Commission was laying blame for delays on the commission, on this commission, on water resource management. And so we just want to provide you folks, in response, I guess, provide you folks a status update of where we are at on the water use permit applications, and provide, I guess, some response to their claims. So this is just a briefing on the status of West Maui water use permit applications regarding Honokowai Aquifer System specifically. This is where the water would be coming from for the Pu'ukoli'i development. And so just a quick background, which you folks are well aware, based on the chairperson's recommendation back in June of 2023, the commission adopted or designated the Lahaina Aquifer sector area as both a surface and groundwater management area. And for the reasons that you see there on the screen, were the reasons behind the designation, including water quantity and quality by saltwater intrusion, various disputes over the years, climate uncertainty, drought, and decline in rainfall and recharge. And so because of the integration or the one-to-one connection between ground and surface water, felt that the water resources should be managed in an integrated manner. And so the effective date of the designation was set at August 6, 2022. And so existing water use permit or existing water users had 1 year to come in for or file water use permits. And so that date was set at August 5th. or 1 year from the effective date of designation was August 5th, but I think it fell on a weekend, so it was set at August 7th, 2023. And so we've received a number of applications throughout West Maui, and also 2 notices were sent to existing users as well as registered stream diversion and well users that they needed to file a water use permit. And so this is the breakdown of uses or withdrawals for groundwater in the 6 aquifer systems. So
Is that the biggest you can make?
Sorry, yes.
Okay.
So for Honokowai specifically, the sustainable yield is set at 6, based on the 12 MAV or moving average. For 2020, it was 3.48. For 2021, it was 4.008 MGD. The authorized planned use is currently at 2.533 MGD. And so just looking at those 2 values alone, we would be exceeding the, if authorized planned use is approved, or as those uses come on board, or water use permits are issued, that already sets us, just that alone sets us at over 6 MGD in use. And so you see there also the 12 MAV as of August 20, from 2022 to 2023 was 4.274. This is just kind of an overview of the area, Honokowai Aquifer. You see all the wells and various wells that are on the ground. And so staff is currently been in the process of reviewing all the permit applications. And so we just started issuing letters to water use permittees or applicants for additional information or clarification on the information provided in their applications. So until we get that information, we'll be giving them 30 days once the letters is sent out after receipt of the letter. And we'll give them 30 days to update that information. But until we receive that information, those applications will not be deemed complete. And so once they are deemed complete, then at that point, that'll initiate the process, the public review, the public notice process, and then eventually bring it before the commission. And so for Honokowai, these are the water use permits, excuse me, Honolulu as well. These are the water use permits that were received. And this is all groundwater use permit applications. You just see the breakdown there. And so staff has prepared letters for all these, and then I'm currently reviewing them to start getting them out. So the biggest being Hawaii Water Service and Kaanapali Land Management. And then we do have one new use application for Kahoma Land.
So where does Pu'u use it?
Pu'ukoli'i is, so in the next map, so this is kind of all the developments that are either have been completed, are on the books, or are being proposed, or in the process, excuse me.
Your prior slides were existing users,
What was that again?
existing users. Your prior slide.
Oh, the prior slide. Yes, these are all the existing use applications that came in. Okay, right. And so these are what you see in green is completed. The green are those projects that have been completed or the water's been committed. The yellow is designated. And so, their intent to build, and then the red ones are still in that conceptual phase for development. And so, again, focusing on the Honokowai Aquifer, there are projects, and actually, let me go to the next one. This is the little clearer one. So I think the mouse should show up. Yeah. So Pu'ukoli'i is right up in here. This entire area is the Kaanapali 2020, so both this yellow part and this red part here. Kaanapali Land Farm, Coffee Farm, excuse me. Pulelehu is down here. These are the DHHL lands, and then Leali'i is down here. So we did note that, so just as an example, in the Hawaii Water Service permit application, there was like one parcel in Puukoli that was included, but overall, we have not received a new water use permit application for new use for Puukoli. And so we were contacted prior to this meeting, the Land Use Commission meeting, by Katia Balasiano, who is a land use development administrator at Office of Planning and Sustainable Development, inquiring about this. And we told her that, we have not received an application for this project. And so until we do receive a new water use permit application, we can't act on it. And so same thing happened after the meeting. She followed up with us and told her the same thing and recommended that, that they reach out to us, specifically Ryan Imata, should they have any questions or about
Did
filing
she
the water use
clarify
permit.
that with the Land Use Commission? That They had not submitted an.
I believe
application?
she was going to, I can't recall exactly our email communication, but she said, got it.
Yeah. So we're being blamed for a non-existent application.
Yeah.
So that satisfies the immediate issue before us, but the larger issue is that's a lot of uses for a small amount of water. So where will the commission be going with that?
So that's why we're focusing.
Balancing there.
That's why we're focusing our efforts on Honoko'ai first, especially since it's all groundwater. We don't really have the complexities of dealing with the ground and surface water interactions. And then once we get there, then we'll move back up north towards Honoko'au, Honolulu, and then start making our way south. Honoko'au is going to be after Honoko'ai, we'll start getting to the complexities of ground and surface water. There's the major diversion from Honoko'au is there, which feeds municipal uses for both private and public developments.
Any progress on the county side with the treatment of the wastewater?
I'm not sure where we last left it, but I think they are more serious about it, but nothing that we've been apprised to.
They got other things on their plate. So how does our Maui temp housing, the waters that's being used for Maui temp housing fold into, because we've been saying if it's an existing use, we've been permitting it. If it's a new use, you've got to wait till our water management process.
Correct. As of now, all of the developments are close to all of the developments are being fed by the county.
Right. Okay.
Those that are prospectively going to be fed, may be fed by private, are currently on hold. And so until we get more information, we haven't moving forward with that. The only one is a small project, which Hawaii Water Service, I think it's only 50 homes for
Golf course.
on the golf course, where they're building the temp housing for the workers. So that's the only thing we need to assess.
I think Commissioner Miiki's concern about, I think we're going to have a lot more challenges in this designation. I mean, we're just not going to have enough.
Yeah.
And I'm really worried about where we're gonna.
Yeah.
And you've got so many different moving parts with the EP, the Maui temp housing, and the restoration of Lahaina.
Yeah. And when is your vacation plan? Pardon me, Fran, that was really unfair. You're doing great. You really are.
To Alexa's credit, when the whole admin bill thing came up, she was looking at the state water code review, and I think was that the 86 or which year was that? Back then they did recognize that the water shortage issues that may would in West Maui, and so back then they were already contemplating designation, and so we're in this situation now.
Doesn't make me feel any better.
Dean, from what you know about this project in the back of the envelope, what do you think the water requirement is going to be?
Pukoli.
Yes.
Um, I have no idea. I can't recall what the.
That's a new,
Yeah,
that's a new use too, right?
That's
Yeah, but
We
I
haven't
mean,
even
they've
looked at
planned it.
existing.
They have a master plan for the development, so I'm sure it's on the book somewhere. I just haven't.
Non-trivial. Yeah.
Yeah, I just haven't
It's a large
looked
number.
at it closely.
I mean, that would give you a sort of a idea of what the pressure is going to look like literally.
And I think, you know, that's where the reuse is going to be very important.
Yeah.
Because that'll may free up a lot of water that would otherwise be used for irrigation.
I'm out of touch a little bit, but with respect, you asked a question about the water reuse plan from behind the treatment plant. And my understanding is it's R1's been available for quite a while, like 3 years now, and it's been used primarily along the coast for irrigation production of the treatment plant. Negotiations are continuing for acquisition of a larger reservoir further up the hill that will provide distribution of the R1 water wider spectrum. Of course, it would have to be pumped up to Pukoli to be used up there, but that's project cost. But it's my understanding that negotiations are continuing and they're headed the right direction with respect to acquisition of an old ag reservoir.
Yeah.
It's still in use in pretty good shape. So,
Remember
and that would solve a lot of the distribution and reuse questions.
Yeah, there's a map on the county website that, yes, does show, I think their plan is going up to that higher reservoir. So.
Yeah, that's gotta happen.
Aurora, did you have a question?
My connection might be a little unstable. I just wanted to offer a little bright spot, at least for me, is that the Water Resources Research Center and we've got a lot of new faculty coming in, including a drinking water specialist. We have wastewater, relatively energetic, very energetic, in a second year wastewater specialist. So, I mean, I hope we can really build some stronger bridges with the agencies and take advantage of that. I don't want to throw Emily under the bus, but she's done potable reuse in different places on the continent. So I hope just knowing that there are specialists at UH, I hope they can be they can inform that really important work.
I see Carolyn, you're here for item C3.
Yes.
Okay, go ahead.
Oh, I really have a lot of catching up to do with regards to the situation in West Maui, and in particular, my interest is the R1 use. And so I'm sorry, Fred, is that your name tag? It's very hard to read on Zoom. It was very educational for me. I'm making some contacts there in Maui. I come from agriculture, and I'm working in Lahaina with my brother in the Kuia area. And water, the lack of water for agriculture is such an issue. And so I'm just moving home, and I'm trying to get caught up on where things are at, where the process is for bringing the R1 water farther south, hopefully. And so trying to just get in the rooms where sometimes this is being talked about and explore, who's been working on this, who's trying to help make this happen, or what are the obstacles, and if there are ways that I can kokua to try to have it move forward. Not that I swing any big sticks, but I've got a lot of energy, and I'm very passionate about this subject and agriculture and the community in Lahaina and West Maui and the environment. So you'll probably see me more, and I think it'll always be friendly, so don't worry. Yeah, but I just know, the water wars have been going on in West Maui for a very long time. The fact that we haven't figured it out how to utilize more of this R1 water that's, been such a wasted resource, in my opinion, for so long, is too bad, and we can't let it continue. I think this is a great turning point and opportunity to especially with all of the interest for how can we improve things in Lahaina for climate resilience, for fuel load, for wildfire mitigation, for climate change resilience, all of the above reasons, the R1 kind of seems like a natural good candidate. So that's where my interest is, and I'm just trying to learn and trying to understand the history and the current status of things, and looking for opportunities to maybe have conversations and try to move it forward, and or see if there's ways that we can help whoever's been trying to move it forward to overcome whatever obstacles might be in the way.
Well, we thank you for joining us today. Thank you very much.
Yes, thank you.
I also, is it Kelly?
It's John.
Yeah.
John Kelly? John, did you want to join, share?
Yes, I'm here. I'm John Helly. My background is as a scientist in oceanography, earth sciences, and geophysics sort of topics. I've been a resident of Maui for 23 years plus, and currently a member of the Board of Water Supply. I'm not speaking for the Board of Water Supply. I'm not representing any points of view in that regard. I was here to understand the timing of the review process for the permits, because despite what I just said, I'm a chair of a temporary investigative group for the Board of Water Supply, and it's important to our planning as to when we expect to see these somewhere between 100 and 200 permit applications in order to review them effectively. However, I think the presentation by Dean addressed my main concern, which is trying to get a status of the timing of all that. And I'll just leave you with a comment that we have a meeting on Thursday that's going to be at least partially addressing some of the issues that were just under discussion. And I'd encourage anyone interested to pay attention to that meeting. Thank you.
Thank you very much, John. So what, I'm sorry, Dean, what was this? What is your schedule for, what did you think?
I think we're hoping to start bringing at least these applications to you for Hono Kauai later this year, towards the end of this year.
Okay.
That's the hope. So we're starting to get the letters out now. Most, if not all of them, should go out this week. And again, this is just for Hono Kauai aquifer. 30 days for them to get the letters or the information back to us, at which point we can initiate the public review and public notice process.
There's also a opportunity for filing a contested case.
Yes, as part of the public. Well, the public, yeah. So the public notice will go out. If there are objections, we'll have to hold a public hearing. I believe at that point, that during the public hearing process, people could request a contested case hearing, or when it gets brought before the commission is another opportunity.
Okay. All right. Commissioners, any other questions for Dean or staff?
Dean, could you, if you think of it, reach out and let me know when those public hearings are and what the schedule.
We'll let
like to
everybody
follow
know.
that along with it. Okay, thanks very much.
That probably would be a good idea to have, board commission presence too, since it's one of the first. Anybody else on Zoom have a comment? Aurora, did you want to add anything?
Well, I was just going to ask Mr. Haley, he mentioned the meeting that was upcoming, if you can share those details verbally with us. That would be helpful.
Just a moment. Details of the schedule for the meeting?
Yeah, you said there was a meeting this week.
Yes, there's a meeting on Thursday, our monthly board meeting at 1:30 in the afternoon. And it's there's an agenda published and it's on the county website. You can look for the Board of Water Supply and that'll lead you hopefully to the agenda.
Okay, thank
you.
If you require more, I'd be happy to send, the link itself.
Okay, very good, thank you. Seeing no other public comments, anybody in the boardroom? Okay, seeing none. Before we close and adjourn, I did want to provide Neil an opportunity, since this is his last meeting with us, some words of wisdom. You can impart that upon us as you take on your next journey of public service.
More words of gratitude than wisdom. And thanks, Don, for affording me this opportunity to say a few words. And as I conclude 2 terms, 8 years of service. And after having read the written transcripts of my oral comments at these meetings, I'm Ivalani, I'll provide you a written transcript so that you can make some sense out of what I say. What looks on paper, what you read on paper, what you said, I'm surprised you understood me half the time, and maybe you didn't. But when you have an opportunity to be a steward of a life-enabling resource like water, it's a profound honor. And I want to thank Governor Ige for appointing me a couple times, and our state senators for confirming me, and appreciate the guidance from our chairs, Case and you, Don. And to my fellow commissioners here, you've been wonderful to work with. I've thoroughly enjoyed it. You've been patient with my questions, respectful of my worldview, and considerate of my position. We had a lot of work to do, and I think we got a lot accomplished. And man, I owe a debt of gratitude and commendation to our staff. Your yeoman's work, I mean, put a lot on our agenda, which we went through, and that's awesome. And I saw, and I'm sure with Dean, I'm sure you're no different, and Jeff was in his own way, pushed the agenda, but I saw that tone set at the top with Kaleo one day when I visited his office. I saw his whiteboard on the wall that counted down the number of meetings under his term of office. And he said, each one that goes by that we don't get stuff on that's meaningful is a lost opportunity. And I took inspiration from that. And I look at our 8-year record. I'm pretty proud of what we accomplished working together and with that sense of urgency. There's a lot to do, and they were wide ranging. The issues were wide ranging. I'm going to say them to you just because in the record, I just want to, understand and recognize how diverse the issues are that come before us. We had impacts of climate change on rainfall, water recharge, and sustainable yield, domestic requirements, well development issues, conservation and drought planning, pollution risks, the Red Hill crisis, wastewater treatment, dual system benefits, water management area designation, stream and marine biology, watersheds, biodiversity, cultural practices, Kuleana rights, traditional customary practices, Kapa'akai analysis, sustainable food system goals, transmission efficiencies, reservoir storage, in-stream flow standards and riparian ecosystem services, permit streamlining, enforcement challenges, sunshine requirements, civic engagement, and integration of stakeholder views. Now, we covered a lot, and it really, and the reason I say it is because we collaborated, we were, as colleagues, bringing really diverse skills and experience to each of those issues. And we needed all of us, to really add value to the whole. I was particularly gratified by some of our achievements, namely the resolution of the long-suffering contested cases of East Maui, Nawaiha, West Kauai, although that one's still in progress, and they're all still in progress. They won't go away, but I think we got through the contested case part, and now we can just adaptively manage. And I'll never forget Kamana's final meeting when he read into the record the name of all those streams that we set in-stream flow standards for. I'm really gratified that the Navy finally came around and accepted responsibility to drain those tanks and repurpose them, and ultimately, and I don't know if it's going to be in my lifetime, remediate that water, that aquifer. I'm glad I know it was controversial at the time, but I'm glad we designated Maui Komohana as a water management area. I think particularly now, is just what we just saw. It needs to be managed in a very thoughtful way, that limited resource. I was really pleased with the restoration of water to Cabela Stream and seeing the people on Molokai, just delighted by that. And Don, I think what you've been doing to really create protocols to more rigorously and to intensify our commitment to a Kapa'akai analysis, I think it's really a good thing. I feel good about that. When we were on our game, I thought 4 factors were present. Number 1, community civic engagement. Man, our community is not, they love water. They love the Aina. They love water. They are deeply engaged. I know it makes our meetings longer, but come on, that's the bedrock of democracy. You know, that we complain that people don't vote or people are apathetic and so forth. I don't think our people are apathetic about water. And yeah, it complicates the process. We just had this discussion of these simple permits, when we want to make sure the public, when they need to have a voice, the public has a voice. It's a challenging thing to manage, but we're better for it. And I found that people who come to the table are knowledgeable about the issues. They're respectful of the process, and they're motivated by Aloha Aina. The second factor is our staff, man. When you guys have the time, and I know you're stretched really thin, when you have the time to do the work, you bring facts to the table, data to the table, you bring good thought to the table. When you're out there consulting with our stakeholders and everybody's opinions, and we witnessed that today, you come up with policy aligned recommendations that make sense, have made our job easy. So thank you for that. And when we as a commission bring our knowledge and experience to the table, I think this commission has done its homework. People come prepared, people contribute. And it's not just a matter of talking, and talking nicely or intelligently. We've had to problem solve. And I think back on our Navaiha and East Maui thing, where we could have talked all day about in-stream uses or off-stream uses and so forth. But when we created the spreadsheet, stream by stream by stream, we made it a math problem. And we tried our best with the math we had. That is how much water and what would be reasonable amounts to dedicate to different uses to solve problems. I think you got to continue to do that. I mean, you can't just talk these things to death. You have to calculate and solve the problems. And finally, just having an ever-present, humble perspective that really elevates public trust over self-interest. We're all put here. We're all encouraged to be here by some constituency. Somebody wants us to be their voice and represent their view and so forth. But I found that once we get here, the hats have to come off. We are one body of 7 around one water code and one mission and so forth. And we're all bringing something unique to it, but we have to act as one. And I felt like we've done that. I really, it was easy. As I think back on 8 years, it's so different from the adage that you hear all the time, whiskey's for drinking and water is for fighting. I don't think that, certainly there's been intense moments, but I don't think that's reflected our work here and how we've approached it. And I think what we know about conflict is that it divides community. It comes at a high cost. It divides community. It impedes and slows action. It depletes our natural resources, and it makes things damned expensive. And that confounds financial viability. So when we can kind of get people to work together, starting with ourselves, I think we get more done. And it's in the motto of this organization. A better mantra than whiskey and water's for fighting is Ole Kawai. Water is not something we should be fighting to own and control for our use and not somebody else's use, our generation and not another generation. It's something that we need to sustainably manage so that we can thrive now and future generations can also thrive. Our kupuna had it, man. If the place is thriving, the people are going to do really well. And that's their simple wisdom. I'm going to miss the work. and I'm gonna miss all of you. Part of me wants to stay, but man, we have a deep bench in our community of really, really talented people who can bring insights and values that are really germane and needed, essential to your deliberations and to the effective implementation of the water code principles. So Governor hasn't named my successor yet, but there's people out there. We have legal representation. We have, business representation, domestic use representation here, and we have agriculture use representation, health. We need to fill this Hawaiian science. We need to fill this Hawaiian cultural practitioner, role, and I think, and continue to work as we have in the past. And I think, and you'll do very well. The progress that we've made, I think, will be sustained and continued. And then we can pupu kahea, holomua kako, get to come together as one, as we have, and then make progress. So I'll be on the other side of Zooms occasionally. Root for me as we shift to Mauna Kea. But thank you for your time and indulgence. Thank you for your friendship, and thank you for your service for what is just something so important to all of Hawaii. So mahalo and aloha.
No, mahalo to you.
Here's what I really said.
Thank you. It is an honor and privilege to serve, isn't it?
Yeah, it is.
It is. Some days are easier than others, but.
Hand us out.
You're just moving, you're moving on, you're moving on to perhaps someplace that may need you.
To a higher and better place.
I wouldn't say I'm better,
It is higher.
but it is they do have different challenges that I think you can bring to the table. But I have.
It's going to be so boring in your new job.
I don't know if it's going to be too boring over there. They have different challenges, but thank you very much. So with that being said, there's an announcement. Oh, shucks, I thought I was doing the last thing. Okay, so sorry. Oh, item D, go ahead.
Let's see where that.
Oh, the next
Next
commission meeting schedule
is July
16th, July 16th.
Right.
July 16th and then August 20th. Are you thinking about changing that date? I know Don said there was some.
Nope.
Okay, they'll
this
fit
time.
into our schedule.
And don't forget the site visit on June 27th.
27th.
Yeah, so just logistically, I think we'll meet here first, and then we'll drive out here, but we'll coordinate with you folks.
Okay, we do.
And that one we were looking at, that was going to be at 11?
Yes, I think.
11?
Wait, what time do we meet here?
Yeah. Or yeah, we'll coordinate that. I mean, some of you, I think, like Dr. Mickey lives on that side, and we can figure that out. But
And it's about it's going to be a half a day.
it's actually only, shoot, I don't have my I don't have the submittal before me.
It's like an hour of driving out there, right?
Yeah.
30 minutes at each location, 6 locations.
So was it 11 to
We're
2?
gonna get back to the intake then?
No, the road is kind of bad. So I did ask Jason Jeremiah to provide, like, if you can provide like a large blown up image that he can talk to.
You gonna come pick me up?
I think we can, so we'll figure that
Meet you
out.
halfway. You call it halfway.
The
call-
opposite direction.
Oh, where do you live? Where do you
I
live?
live in Kalu.
Oh, they could drive that way out to Punaluu. They'll have to pass your place.
That's a slow way.
Pick me
The
up.
one lane.
No, actually,
Punaluu, yeah. you go
Punaluu
this
is
way.
easier to go through Kamehameha Highway, this way through Kaneohe. The other way would, to me, the cutoff point is,
Aliva.
no, Turtle Bay.
Yeah.
Anything west of Turtle Bay, easier to go along through.
Punaluu is pretty close.
Yeah, yeah. So, no, thank you. So we'll meet back. Well, you'll send us out more information to follow up on that. Okay. So with that being said, I don't know, Dean, did you want to say anything? Nope.